Yeah. Yes. What's that?
May I please, Your Lordship?
Yes.
Lordship, I beg to mention item number 23. Your Lordship, here by the order 26/9/2024, I was directed to obtain the full set of the Pay Anomaly Committee.
Yes, yes.
But that order, our name was not mentioned and order is came out separately. So unless the order rectified, directing the state respondent to submit a full report of the Pay Anomaly Committee. So I cannot take the step. So Your Lordship may grant me some more
additional
time.
affidavit you have filed.
I filed. I have filed
It was not.
additional affidavit on 3rd September, and it came out on 26th September again. So, and on 26th September, the petitioner prayed to the Honorable Court that to submit a full set of the Pay Anomaly Committee. So, the order was verbally passed, but in the order, nothing was mentioned. Maybe because of the
I think in the order it was mentioned only.
Verbally, they have submitted and court also agreed.
No, it was in the order.
But it was not in the order because our presence was not reflected. It was reflected somewhere. Maybe because of the difficulties in the variation of the cost list.
23. Well, what do you want now?
Now, as per prayed for by the petitioner, is the respondent, unless there is a clear-cut order from this honorable court, I cannot obtain any instruction.
No. So, Mr. M.T. Advocate, Additional Advocate General has submitted that he will obtain the full copy of the report immediately after vacation. Is there?
On 26th.
Yes.
But whatever I have downloaded from here, it is, my name was not there, Joshua, petitioner counsel name was not there, Nidu Koza and Enangami for the state respondent.
26.
26.
Mr. M. Song Lan, Additional Advocate General has submitted that he will obtain the full copy of the report immediately after vacation. Is there?
Then there's a problem again. Whatever order I have obtained under the order the 26/9.
Mhm.
So the order is with me is a different order.
Different order.
Yes,
Can I just see?
and because of which I cannot obtain the instruction from the department.
How it is? Minus. It's showing. How it is? Compare it, the numbers and all.
Yeah.
Hmm.
Even the costless order, there was a problem, and the order also now, there's a problem here. Whatever I have obtained from the,
No, it is there only.
yes, it's already there, but when I obtained this order, in
Hmm.
order to communicate with my client, this was the
Is
order.
the number same?
Yes, same. Party names was same, except the council.
Then the registry need to clarify how they
Yes.
have issued. Who issued this? CTC?
CTC obtained from the
Mhm.
court website.
Obtain this one?
E-code.
Hmm?
From the E-code.
E-code. Now obtain CTC. So then you obtain,
Then I have to
As per this
apply for
order?
the CTC.
the order is there.
Yeah, and unless your lordship grants some more time,
Okay,
I then,
okay, please pass it. Let me just see what. Same. No, this order is altogether different. Not even a year. This is not CTC, this is,
not CTC.
okay.
On the following day, I just downloaded from the court website.
This is the counter, filing of counter state, affidavit stage. Okay, Mr. M.T. himself, Learned Additional Advocate General. Raise for some more time to obtain full copy of the report. This is a report of the committee on pay anomalies. The, how much time it will require?
2 weeks time.
Okay, he is granted further 2 week time to obtain the report. Okay, Miss
Mika.
Mika, Learned Counsel for the petitioner is present. Let's pray for Rama. list this matter after 2 weeks.
So bless.
Yes, sir.
Yes.
Next one, which one? Item number 25.
Item
Is it 25?
5. Okay, what do you want? Yes, make appeal. Yes, you are for appellant. And who is for the respondent? Is present.
I'll inform you.
You'll inform. Is your case? Are they present today?
Okay.
Why you want the adjournment? Okay, Mr. Limo, Land Council for the appellant. Praise for how much time?
Next Monday, 21.
Okay, praise for listing this matter. And then where Limo Wapang, Land Council for the appellant with the consent of the Land Council for the respondent. Praise for listing this matter
On the one.
next week. 20 Monday.
Monday.
Okay. The prayer is allowed. List it accordingly. List it on Monday. Okay.
May I please, my lord?
Yes.
Lordship, I beg to mention item number 11 on behalf of my colleague KV. Angami, your lordship, he has some personal difficulties today. I'm also informed that he is the performer respondent in this matter, my lord.
Okay. So you're for respondent. Who is for the, okay. Mr. Angami, huh? Appearing on behalf of Mr. K. Angami. KB Angami, Land Council for the respondent. State respondent.
Yes, my lord.
Okay, praise for
A week time, my lord.
a week time. Adjournment of the case for a week, huh? To which Miss Mika Land Council for the petitioner has no objection. Accordingly, the prayer is allowed. List this matter after a week. Okay.
His lordship, there's an interim.
Okay. The interim order passed earlier shall continue to the next date. Okay.
Lordship, at the LCR is yet to be called.
Oh, not yet.
Yet.
Where is it? Good. Then wait, huh? Okay, huh? Then after that. For proper adjudication of the case, the trial court record will be necessary. Accordingly, call for the record. Last is pray for comma. List is matter after 3 weeks.
Lordship. Obligement.
May I please?
Yes.
Lordship, I beg to mention item number 6, Lordship.
Item 6.
Yes, Lord.
Yes.
On behalf of the council for the respondent, Sir P.P. Paul, Lordship. Lordship, he is indisposed today, Lordship. So I pray that this matter may come up after 3 weeks, Lordship.
Okay. Mr. Medavero, Land Council, Land Advocate. Praise for
3 weeks time, Lordship.
submit the council, Land Council for the respondent is indisposed. And hence pray for 3 weeks time, adjournment of the case for 3 weeks, to which Mr. Parking Chabot, Land Council for the petitioner has no objection. They are allowed to list this matter after 3 weeks.
Much obliged, Lordship.
Okay.
May I please, the lordship, your lordship, I beg to mention hearing item number 24. Kindly allow the matter to be listed after 2 weeks, as my senior counsel is not feeling well.
Is it Mac appeal only? Here for the respondent.
Yes, your lordship.
I mean, appearing on behalf of become the block for the appellants.
You are appearing on behalf of Devnath.
Yes, Lordship.
Okay, you are appearing on behalf, okay, Miss,
Renboni,
your senior is?
I Apok Pongner
Okay, what happened to him?
is not feeling well, your lordship.
Okay. Miss Samis, the Lana advocate, Samis. Your name is also there?
Yes, your lordship.
Okay, Lana counsel. For the appearance, Samis that is senior, her senior agent in this post and prays for adjournment of the matter for
2 weeks.
2 weeks. 2 weeks, 2 weeks, huh? Mr. Medovero appear on behalf of Mr. B. Devnath, Lana counsel for appellant, and he has no objection, start. Accordingly, the prayer, the case stands adjourned, list this matter after
2 weeks.
2 weeks, okay.
Pleasure.
Much.
May I please, my lord?
Yes,
Lordship, I beg to mention item number 14. Lordship, in this matter, I may bring for respondent number 1.
yes,
Lordship, I am yet to receive instruction in this matter. However, your lordship, as for the respondent number 2, 3, and 4, since it is in the order column, it appears that the notice upon the respondent number 2, 3, and 4 may not have been completed, my lord.
okay, you are for respondent number
One
one,
only, my lord, one only.
okay,
So can kindly peruse the order 16/8/2024, my lord.
what is that?
Mr. K. Angami has already appeared for the rest of the respondents, and also the notice is
Already
complete.
appeared for
For the other respondents, that is 2,
2,
3,
3, and
and 4.
4.
Lordship. Then in that case, your lordship, on behalf of KV as well.
Okay, Miss Luzina, Lana counsel for the petitioner is present, start. Mr. Angami. Lana counsel for the respondent number 1, submits that he is yet to receive instruction and prays for some more time. He is yet to receive instruction, huh? Instruction. He is not present, Angami.
Lordship, lordship.
Okay. Prays for some more time. The prayer is allowed. List this matter after?
3 weeks, my lord.
After 3 weeks. Okay. In the meantime, he inform him as well.
Yes.
Okay.
Should the notice is being completed, so since it's listed in the orders today.
Okay. The is pray for list this matter after 3 weeks. In the meantime, you file. Then we'll list it in the admission.
No, your lordship, Mr. KV is appearing for the other respondent, and this
Okay.
notice is deemed to be completed, my lord.
Okay. Since Mr. KB Angami already appeared on behalf of the respondent number 2, 3, and 4, the notice is completed.
Lordship.
Yeah, okay. This is matter after 2 weeks.
Deeply obliged, my lord.
Yes.
I beg to mention item number 13. I'm appearing for my senior young working for a big senior young. Your lordship, is for the last order, date 6/9/24, your lordship. This one.
You for
I'm for a petitioner, your lordship.
item 13,
Yes, your lordship.
fresh step not yet taken.
Yes, your lordship. It's for the last order. Court has directed us to take a first step
Yes.
on respondent number 2, your lordship, which we have already taken. But your lordship, we are yet to receive a report to file our affidavit to that effect. So I pray that if.
You have taken steps
Yes, Lord.
by way of,
Dusty service. Your lord.
Dusty.
It's for the court order.
okay, so affidavit not yet filed.
Yes, sir.
Please, record, let us see the record. Have you seen the record?
Oh, your lord.
So what do you want now?
To file
Since
the
we have
affidavit.
taken steps,
Yes, your lordship. We are waiting for the report. your lord.
you wanted to file affidavit. Have you filed?
Not yet, my lord.
You are also praying for some time.
Yes, my lord. 2 weeks, my lord.
So as per the report, you have not yet taken steps You have taken otherwise.
Yes, your lordship, after the court order, your lordship, after the directions were
Okay.
already taken steps.
But this, the report is on 10th. Court order is on 9 September, but the report is of October. October 3rd, you have not yet taken steps. When did you take step?
Your lordship, I actually can't remember the date.
No, as per report, you have not yet taken step. As per the report, office note. Are you sure you have taken steps?
Your lordship, from our side, we have already prepared.
Hmm?
From our side, your lordship, we have already prepared for the decision.
No. 310, no steps taken upon respondent number 2 by the petitioner.
Yes, your lordship.
When did you take steps?
Lordship, I actually can't remember the date, your lordship.
No, after 3rd?
No, after the order 6.
No, the 310 report, office note says that you have not yet taken step. 310. You find out, check.
Yes, your lordship.
You are Mr.
Jim Yang from appearing for my senior young warrior.
Appearing on behalf of Mr. Yangaravati Land Counsel for the petitioner.
Yes.
Submits that he has taken steps upon the respondent number 2 by way of dusty service. However, affidavit to that effect has not yet filed and prays for some time. Mr. Pakinrichabo, Land Counsel for the respondent, also prays for some more time to file affidavit in opposition. Stop, para. Is prayed for by the parties, this matter after 3 weeks.
My lord, I'm appearing for
We
respondent
filed
number
the
1.
time. Hmm?
I'm appearing for
Mr.
respondent number 1.
Respondent number 1, I'm Pakinrichabo, for respondent number 1. Okay,
Well, but
this is item 13. Okay,
May I please, your lordship,
yes,
our lordship, I beg to mention item number 16 and 17.
16 and 17.
Yes, lordship, here the case is under consideration. So lordship, I pray that this matter may come up after 3 weeks.
Okay, you are Mr.
On behalf of my senior merchant.
Okay. Appear on behalf of Mr. Muazzam Land Counsel for the petitioner. Ms. Shukri, then additional appearing on behalf of respondent, respondent number.
For all the respondents.
Okay, for respondents, submits that the matter is under consideration and pray for some more time.
Mm.
How much time?
3 weeks, your lordship.
Prays for the 3 weeks time. Stop. The prayer is allowed. List this matter after 3 weeks. 16 and 17.
Yes, lordship.
Okay.
Yes. Much more.
The case of the petitioner is under consideration, not the matter. Okay.
May
Yes.
please, your lordship,
Hmm.
I beg to mention item 15.
Item 15.
Yes.
Yes, what?
I have received instruction only this morning to appear on behalf of respondent number 3 and 5
Appearing for the first time.
for the first time, my lord, in
Okay.
this contempt petition.
Who is for the
so-
petitioner?
May I pray that 3 weeks time may be granted so as to file my power as well as to obtain instruction and find my affidavit.
Okay. You are for?
Respondent to my lord.
2.
Yes, my file my lord. That amount of position.
You have already
Yes.
filed. Okay. You are for?
For respondent 6.
6. You are for?
Respondent number 1.
1. In the mention, everyone is appearing. Okay.
Lordship, Lordship, we are informed that the respondent number 6, has been transferred, Lordship, and a new, incumbent has been posted, so can we allow us to implead the respondent number 6
Okay.
as new respondent?
Ms. Mika Elana, counsel for the petitioner. Submits that the respondent number 6 has been transferred out and some other officers has been posted in his place and prays for some time to file implement, to file IA for, IA for implement of the new incumbent. Start. Mr. Respondent number one,
Your Lordship, I am.
okay, Mr. Angami, counsel for the respondent, you have already filed,
No, Your Lordship. I am
Okay.
also yet to receive instruction.
one. And which for two, you have
My
already
lord,
filed, okay,
That in
also pray for some more.
my
time
lord,
to file
I filed
affidavit.
like all, affidavit of opposition.
One, huh? One. only.
Respondent number two, my lord.
Two already filed,
Yes.
okay. Mr.
My lord, I'm for 3 and 5.
Oh, respondent number two, Mr. Oh,
That in only my lord.
okay. Learning counsel for the respondent number two is also present. And Mr.
LT Sanktan for
And-
3 and 5.
Put here on behalf of the respondent number 3 and 5 and prays for some more time to obtain instruction and to file affidavit in opposition. So, para, in view of the above, list this matter
After 3 weeks.
after 3 weeks. Okay.
Much.
In view of the above submission of the parties, list this matter after 3 weeks. Okay.
Mr. Lordship, I
Yes,
beg to mention item 21, hearing item.
item 21.
Yes, this
What do you
is
want?
that after 3 weeks,
Okay, you are for the petitioner.
yes, for the petitioner.
Okay.
No objection.
Hmm. Miss Lana Counsel for the appellant prays for listing this matter after 2 weeks. To which Miss Luciana Lana Counsel appearing on behalf of the respondent has no objection. The prayer is allowed, list this matter after 3 weeks. Okay,
Consider prayer for item 22, Lordship.
item,
22, hearing for the respondent number 1.
so who is for the petitioner? Have you informed?
Yes.
Okay. Miss, okay, her name.
Procedural.
For respondent number
1,
1. After 3 weeks,
after 1 week.
after 1 week. Praise for listing this matter after 1 week, to which Mr. Miss Mika Lana counsel for the petitioner has no objection. Prayer allowed, list this matter after a week.
Bless.
May I please, your lordship.
Yes,
Lordship, I beg to mention, item number 19 and 20, lordship.
19 and 20,
Lordship, it is the joint prayer of the parties, lordship.
is it?
Yes, lordship. Let it come up on 22nd of November, October, next week, lordship.
Then in that case, part hard will be released.
But next week only, lordship.
Hmm?
22nd October, next week.
22nd October. Or the joint prayer made by both the Lana counsel for the parties, list this matter again on
22nd
22nd
October.
October. Okay.
Much obliged.
May it please your lordship, I beg to mention item number 24, your lordship.
22nd.
I'm appearing on behalf of my senior, Mr. Kachisi,
Item
24,
24.
appearing on behalf of my,
24 already mentioned.
okay, sure.
If you want double adjournment,
Your
we can
lordship,
extend.
I would also like to mention item number 1. your
Item
lordship.
1.
Yes, due to some personal difficulties.
Only
senior-
notice to be, so you are here, you are for the petitioner.
Yes, your lordship, but I'm not in this case. I'm
Okay.
appearing on behalf of Sir Likase Samtam, Senior Likase Samtam.
Okay, Miss,
Pass over for tomorrow, your lordship. Kindly.
okay, then item 1, pass up, list this matter tomorrow. Huh? Okay.
Much appreciated.
For motion, item number 2.
Okay,
Please, your lordship,
yes,
this present contempt petition is being filed to initiate contempt proceedings for non-compliance of this honorable court order dated 05/12/2023, passed in the
Will issue notice. Card miss. Name? Ayala Imchen. Land counsel for the petitioner. Fair. This is an application under section, filed under section 11 and 12 of the Contempt of Court, the Courts Act 1971. Read with Contempt of Court, Gauhati High Court Rules 1977, and Article 215 of the Constitution of India. For non-compliance of the order dated 5/12/2023, passed in WPC number 79/2023. Stop. Issue notice. Returnable by 4 weeks. Alright. The petitioner shall take steps upon the respondent by a registered post which lady within a week from today. Stop. List this matter after 4 weeks. Okay.
For motion, item number 3.
Please, your read.
Yes.
This contempt petition is initiated for a non-compliance of this honorable court dated 7/12/2023, passed in WPC number 228 of 2023.
For a detail,
Order dated
7/12.
10/12/2023.
let us see the direction. What is the direction? 2 weeks from the date of receipt of copy of this order. So when it was passed on 7/12. You have written. Have you written reminder? Service copy, okay. Okay, Mr.
There.
Akam,
Higher.
Land counsel for the petitioner, stop para. This is an application under section 11 and 12 of the Contempt of Courts Act 1971, read with Contempt of Courts, Gauhati High Court Rules 1977, and Article 215 of the Constitution of India, India, for non-compliance of the order dated 7/12/2023, passed by this court in WPC number 228 of 2023. Stop. Issue notice. Now, hard and consider. Then issue notice. Returnable by 4 weeks. The petitioner shall take steps upon. How many respondents? Respondents by a registered post with AD within 7 days from today. Stop. List this matter after 4 weeks. Okay. Much.
For motion, item number 4.
Yes, yes.
About this is a application under for to share to see for question of the fire. And in this case, this matter is purely out of a financial transaction, and the petitioner and the complainant I settled the matter amicably between the parties. So it was issued the notice can kindly be sent.
It appears that this is the only financial or the transaction between two parties. Ms. Mere? Hmm.
Lordship, let notice go. Without instruction, I cannot say anything right now.
Is it joint petition or?
No,
No,
no.
my,
Okay, then in that case. Okay. Card, Mr.
you know, but
Land counsel for the petitioner. Para, this is an application filed under section 482 of CRPC. I think you have to insert the correspondence DNS also for passing of FIR. Okay, so this is still under investigation stage.
see, it has not been charged.
When was the FIR lodged? When it was registered?
January. The file is at page 10.
Is 23. Case has not yet been charge sheeted,
No, my lord.
still under investigation. Case of 2023,
It is of 24. January
24.
2024.
13/9/2023. What is this then? Okay. What is this date? 30/09/23. Officer in charge. It was received. But again, somewhere is January 24. 19/9/2023 again. Suburban Police Station. Where have you written the PS case?
That is at page 1.
Okay. Praying for passing of FIR number 06/2024. Dated 26/01/2024. Registered as Suburban PS case number 06/2024. Within bracket GR number 36/2024 bracket close. Under section 420/409 IPC. Stop. Call for CD? Or
Lordship,
okay, call for
Scanned copy.
scanned copy of the case diary. Since Ms. Mere appeared and accepted notice on behalf of the state respondent. The Ilana PP, huh? Appeared and accepted notice on behalf of the state respondent. No formal notice need be issued to the said respondent staff. The petitioner shall take steps upon the respondent number 2 by a registered post with AD within 7 days from today. Stop. No, within 3 days from today. When do you want?
My lord, I may
After
be
the-
allowed to take steps by way of Dusty also.
Dusty.
Yes, ma'am.
Dusty is also allowed. Stop. Better. List this matter
After a week.
after a week. Okay.
For motion, item number 5.
Lord, this is also an application under 482. My lord, in this case also the parties compromised the matter among themselves.
This case of which year? 2023.
2023, my lord.
Case, whether the case has been charge sheeted?
It has been charged sheeted.
Okay, what is the stage of the trial?
Now, at the end of this month, it is fixed for CC. Hello.
CC.
Yes, my lord. So at this stage, I'm also praying for an interim for a stay of proceeding.
What is your prayer? Let us see your prayer.
That is at page 13, my lord.
There's no water.
Interim praiser is at page 14, my lord.
Just a minute. Huh? Okay, so this is accident case.
Yes, my lord.
So the parties have entered into the agreement,
Yes, my lord.
settle the matter.
Yes, my lord.
Okay, we can issue the notice. In the meantime, in such cases,
Interim may be considered on the returnable date, your lordship,
is it?
because,
So
yes,
this is
your
accident case, and then they have,
lordship,
for
it's not a
much.
joint petition, so granting of interim
So
at this stage will amount to
you
interference.
say
your
that
lordship.
the parties have entered into agreement. It's not a joint petition.
Not a joint petition.
Why? He's not agreeing with the,
Nothing
Why?
as such, my lord.
Hmm?
Nothing as such, my lord.
okay. Then
Matter has been compromised between parties.
in that case, you could have filed this joint petition by both the parties. Again, over and again, you have to issue notice, then he has to contest. It appears there is more than one agreement.
Yes,
At one go, it did not happen.
there were two persons injured in this case.
Okay,
So,
with a different person.
yes,
Where in the agreement, it is stated that. Let us just see one. That they don't want to pursue the matter. It's a that case, it appears.
negative for my lord. Page 21,
2-1,
21, negative for.
where?
This is
Says
a
agree to
compromised deed.
forgive, okay. And pardon. Last para.
Yes, my lord.
Okay. Will issue notice.
Lordship,
The father of the deceased has agreed and forgiven. And he has agreed to.
And then he is the
compromise.
complainant in the case.
Okay. So stay after obtaining record.
lordship, LCR has to be called. It's a charge sheeted case.
Okay. Hard, Mr.
Vino Kachumi.
Planning Council for the petition. Start. This is an application under section 482 of the Criminal Procedure Code for quashing of. You're basically praying for quashing of the GR case already registered before the court.
FIR and charge sheet board.
Okay, GR number 712/2023 arising out of the FIR number 84/2024 registered as Deep Hooper, ES case number 84/2024 under section 279 304A IPC Railway Section 184 MV Act, MV Act. Call for the scanned copy of the trial court record. So issue notice returnable by, it'll be
After the registry released the matter, after it released,
Received.
received, yes.
okay. 2 weeks.
Once the LCR is received by the registry, that can be
So it won't take much time, probably.
lodged.
We'll say next week. If there is no
Whether,
case,
yes,
I
yes, your
think
lordship,
no point
lordship,
carrying on.
lordship, lordship,
okay.
I have no problem with that.
Okay. Next week, huh? The party is in your contact, probably,
Yes, my lord.
okay. The opposite party.
Yes.
Okay. Issue notice returnable by, we'll fix date then, in that case. So it will be on 24th, Thursday. Okay. Since Miss Mary Lanet PP accepted notice on behalf of the state respondent, no formal notice need be issued to the said respondent. Stop. The petitioner shall take steps upon the respondent number 2 and 3 by
Dusty service only.
way of dusty service. Take steps upon respondent, as prayed for by the petitioner, comma. The dusty is allowed. The petitioner shall file affidavit after. To that effect, List this matter on see 20. We say 20.
24.
24, okay. Okay.
Obliged, my lord. For motion from the supplementary clause list, item number 26.
Yes.
Mr. Lordship, Your Lordship, the petitioner here is a young lady. She's 25 years, Lordship. She is currently engaged as one of the independent representative under V Hunt Direct Selling Private Limited, which is a franchisee of QNet. It's a e-commerce business, Lordship. Now, what has happened in this case is that the petitioner and the complainant, they knew each other. They've been friends for some years. And then since they've been in contact, and the petitioner has been engaged as an independent representative, Lordship. The complainant also showed his interest to join her business, Lordship, and also applied the same. So there was complete transparency in the transaction, Lordship. Now, via email dated 24th March 2023, Lordship, which is annex in page number 25,
Yes.
number 25, Lordship.
Yes.
So here, this is how the business started. Since the complainant said he wants to join. So Lordship, if you on perusal
This
of
is a letter
the,
written by complainant, informant.
This is the email communication transacted between the complainant and the petitioner.
Okay, this email was written by,
This email was written by the first mail was written by the petitioner to the complainant, saying that, Lordship, can you allow me to read it, Lordship?
yes.
Email dated 24th March 2023 at 19:28. Dear Toshi Jamir, as per our discussion regarding your joining.
Is informant?
Yes, this is the complainant, Lordship.
Okay.
As per our discussions regarding your joining this business, I'm sending this email to you, and the agreement that we have to execute is attached to this mail. Please read it carefully and in complete details, and if you're agreeable to the terms and conditions of the agreement, please send your acceptance to the agreement by return email saying I have gone through and agreed to all the terms and conditions of the agreement. If you do not agree, please send email your response accordingly. Please intimate the products to be purchased for you. Please also go through the attached agreement carefully and go through all the terms and conditions in detail before accepting. I shall proceed with the purchase of products selected by you only after your written confirmation. Now, in response to this, Lordship, the complainant has promptly responded saying that in the below is the response of the complainant, Lordship. So it says, Dear Kane Javitsa, I have carefully gone through the terms and conditions of the agreement attached in your email, and I accept all the terms and conditions of the agreement. Please purchase the following products from me from international domain of the company from the amount paid by me to you for purchase of products, Trip Saver Basic 2 numbers and Trip Saver Lite 1 number
Okay.
from New Zealand portal, as I've always wanted to travel there. Regards, Toshi Jamir. No, Lordship, according to this, transaction was already done. He has deposited 1,30,000, Lordship, to the QNet company, Lordship. Now, what has happened was in 2 installments, one in 50,000 and 80,000, Lordship. So by that, the following pages from 27, page number 27, 28, these are the transaction details, Lordship.
What is the FIR?
Now, Lordship, the FIR is in page number 35. Page number 35.
Thereafter, they have entered into the agreement also. Agreement also
Yes,
she has signed.
agreement is already executed, Lordship.
Okay.
And then in the agreement, it is clearly written,
Page
Lordship.
31.
Yes, from page number 31 till 34, Lordships. There are certain terms and conditions which
Okay.
the complainant has clearly agreed. Now, in fact, this is a civil matter, Lordship. This is a civil matter because the complainant in his with his own on his own volition has agreed to be, to
Yes.
transact, to do all the transaction, has become an independent representative.
What is the complaint against her?
Now, the complaint was, in fact, the complaint is not directly against the petitioner, Lordship. If you see the nature of the complaint, Lordship, it is said a complaint against QNet, Lordship, with effect on page number 35, Lordship.
Complaints.
Yes. So against QNet, a multi-level marketing company. This is what, but then again, she has been named as one of the accused, Lordship. So she has already been summoned. She has been cooperating with the investigating agency, Lordship. Already she has been summoned. She has also been cooperative, and then she also, helped the investigating agency by furnishing all the relevant documents which will help the case. But again, she has received summon again, Lordship.
Notice.
Notice again, Lordship. She has been, she's now presently residing in Noida, UP, Lordship. Now she has been summoned. Just 2 3 days back, she received the summon through WhatsApp. Lordship, copy of which.
Earlier also issued.
Yes, so she has complied. Now this is the subsequent notice that she has received. She's supposed to report.
On notice issued by the police, whether she has appeared before the police?
Yes, initially she has been cooperative. She has done through, in fact, she was also examined through Zoom conference also, Lordship.
Okay.
Yes. On 6th August 2024. So she has been again summoned to appear physically before on 18th of October before Tuli Police Station, Mokokchung District, Lordship. So she has high apprehension that if she appears, she may be arrested, Lordship. That's why this application has been moved.
Otherwise, you are ready to appear.
Yes, I'm ready to appear, although I'm residing in Noida, Lordship.
Yes, Ms. Mayor, it appears that there is an agreement.
Also, Lordship, the products which the complainant has purchase, Lordship. It is still valid, Lordship, valid for 5 years. The product is with him, just that because he failed in the business, he was not
Okay,
successful,
Daddy.
Lordship.
Let a short notice go, Your
Okay.
Lordship.
Miss, Itokoza,
Lordship, I have an interim prayer.
Itokoza, Nara counsel for the petitioner.
Lordship, in this case, I'm assisted by Mr. Counsel Akash Kumar. He's appearing virtually, Lordship.
Okay, it's fine. I think you're enough. Okay, Miss, and then this is an application, just a minute, huh? The petitioner. Accused petitioner, huh?
Yes, Lordship.
File this application. Under, file this pre-arrest bail application under section 438 CRPC. Apprehending her arrest in connection with Tuli Police Station case number 016
Yes, Lordship.
016
2023.
2023 under section 417, 418, 420 of IPC. Start. The Lorry Council for the petitioner submits that based on the FIR lodged by one. What is the name of the informant? Ait Hosi Jamil
Yes, Lordship.
before the Director General of Police, Nagaland.
Which was transferred to Tuli Police Station.
Police headquarters, which was forwarded to no, to the where do we find it? It was forwarded and transferred. Is there any forwarding?
Forwarding
Any-
letter is
any-
not there, Lordship.
Okay.
If you see page number 37,
Okay, forwarded to the OCPS Tuli Police Station and registered as Tuli PS case number 016 2023 under section 417, 418, 420 IPC. The further case of the petitioner is that the petitioner and the informant entered into agreement. This is agreement is for what?
agreement is
For
for
selling.
making purchase, Lordship.
Hmm?
For making purchase and also
Oh.
to join the direct selling venture as the petitioner, Lordship. As independent representative, in other words. This is a business which runs similar to Amway
Entered into a
or Reflect.
business of selling purchase,
Yes, Lordship.
selling, stock reselling. No, selling and purchase. What is MLM?
Lordship, it's a
And for joining of
multi-layer,
ML,
multi-level marketing.
multi-level marketing business of
company.
Vihan Direct Selling India Private Limited. And according to you have delivered the goods.
The goods has been delivered. It's still active, Lordship.
Hmm.
There was a clause in fact, Lordship.
After entering into the agreement, the petitioner has delivered the goods. Agreement for five years.
Yes, Lordship.
For 5 years, the petitioner entered into agreement for 5 years.
The product is active for 5 years, Lordship.
Okay.
Your Lordship, may I interject at this point, Your Lordship?
Deliver the goods to the informant.
Your Lordship, may I interject at this point? Am I
Yes.
audible?
Yes, what is that?
Your Lordship, with my humble submission is that the product, that these are not the physical products. It's a travel package.
Okay.
It is not a physical product that has to be delivered physically to the complainant.
What is
It is a travel.
What is to be named it then?
It's a tour package, Your Lordship.
Tour package. Enter into agreement. Tour package. Tour package.
Yes, Your Lordship. Tour package. It's a travel package which he has purchased.
Tour package.
Right.
Then instead of selling it, because in the agreement becomes seller,
Yes, Lord.
reseller, distributor.
This agreement pertains to becoming a direct seller and getting associated with the Vihan Direct Selling Private Limited, Your Lordship.
Okay.
The basic condition of joining this business is that you have to purchase a product, and that is what the complainant actually did. He purchased the product and he is meant to avail that product. There are multiple products which are in the form of physical products as well as the product in the nature of travel.
This agreement is for last for. Agreement is for.
This agreement, there is no validity time period for this agreement. The product that he purchased, the product that the complainant purchased for himself is meant for 5 years, Your Lordship.
Okay. However, during the course of the business, the informant has lodged the above FIR. As a result, the police has issued a notice under section 441 A CRPC. So the accused applicant is ready to cooperate. However, since the police has already issued notice, she has an apprehension that the police might arrest her and cause unnecessary harassment staff. Hence, this pre-arrest bail staff para issue call for the scanned copy of the case diary issue notice. Since Ms. Mary appeared on behalf of the state respondent, Lana BP appeared on behalf of the state respondent. No formal notice required to be issued. Staff. List this matter. After a week or two,
Lordship.
after a week, stop. Sarah. In the meantime, as an interim, in the event of the accused applicant, Miss, what is her name?
Khane Jibitsa.
Khane Jibitsa is being arrested in connection with the above PS case number 016/2023 under section 417, 418, 420 of IPC, C shall be released on interim anticipatory bail on execution of a bail bond of rupees 50,000 with one surety of like amount to the satisfaction of the arresting authority, with the further condition that she will cooperate and appear before the eye of the case as and when called for. Stop. List this matter after a week. Okay.
Your Lordship, there is one more submission in light of the recent events that the petitioner has been again issued a notice for joining on 18th of October, just 4 days later. So she,
You already appeared, and an agent, when you appeared, the police will release.
that is there, Your Lordship, but there is one problem that the order Your Lordship has just passed. It says that she will comply with all the terms and conditions and join the investigation. But since today it is 14th, and even if she leaves today, if she leaves Delhi today and wants to join the
I'm not giving any date. Sooner the better for you. If you appear, agent, when
I'm
you
just
Ayo, if you don't
I'm
appear,
ju-
you will not do anything.
I agree, Your Lordship. It's just my request that on 18th I may be allowed to join through VC, through Zoom application, because it's just 3 days time from now. Otherwise, not joining on 18th would lead to non-compliance of the.
You are now protected by interim order.
Yes, Lordship. All right. Grateful, Your Lordship.
For admission, item numbers 7 to 9.
Yes.
On last occasion, LCR was called for. I do not know whether the records have been received or not.
This is. Okay.
On 27/6/2024. I think it is received.
Yes.
May I please, Your Lordship?
Yes, this is.
There are 3 analogous cases. And if one is decided, then automatically the other 2 will be covered.
Okay.
The same issue is involved in all the 3 cases. The issue involved in this case is very short, but then short background will be necessary to
Right.
understand the facts of the case. The present writ petition has been filed challenging the order dated 6/6/2024 passed in civil miss case number 3 of 2024 arising out of one civil case which is civil suit which is pending in District Judge Uka. The brief facts, Lordship, IA was filed in the suit for deletion of the names.
Was basically for.
It was under Order 1, Rule 10, Clause 2 of the CPC for deletion of the names of the present petitioner. The case which arose was out of a dispute for separation of 3 independent churches. Uka Town Baptist Church was established in the year 1919. And that time, the town was small. So under one church, all the believers used to worship in that church under the name and style of Uka Town Baptist Church. But in due course, over a century, town sprang up, so many populations, believers increased, and town has also been expanded to a great extent. So it was not possible to worship together only in one church. as Lordship has seen the Oka town, the largeness of Oka town, how it is expanded now. So for convenience of the believers, the fellowship churches under the main church, fellowship churches were established in few colonies for the convenience of the believers. For example, on Wednesday, services are there, Saturday evening with services are there, so they can worship in the fellowship churches. Now, sometime in 2017-18, the church has taken some decisions for granting independent status to the 3 churches. Discussions were on, but then it was not finalized. And a decision was taken that in 2019, in the month of December, the centenary celebration will be there. Therefore, after the centenary celebration, the 3 fellowship can be granted independent status. They should be released and then they should manage independently. That was the decision taken prior to the centenary celebration, but to be implemented up to the centenary celebration in the month of December 2019. That was the decision taken in the General Assembly meeting. Now, although the decision was taken, it was not implemented and centenary was celebrated in December 2019. And then before anything could be done, Lordship is well aware, in sometime in the month of March 2020, COVID-19 pandemic has hit the entire world. So nothing could be done. So situation continued like that. But then since when the situation turned to normal, then the believers of 3 churches has reminded and approached the mother church, that is the main church, which is Oka Town Baptist Church, who are the main respondent here. Look, we have already taken a decision to grant independent status to the 3 churches, but that has not been implemented. So please implement that. Now that situation has come to normal, like that. And in due course, some problem cropped up that among the 3 fellowship members also, believers, some still wants to attach with the mother church and some wants to be independent. So there was some sort of a law and order problem. So in view of that, the Deputy Commissioner convened a meeting. In that meeting, the Lutha Hoho, which is the fixed body, that was also invited. And then Lutha Women's Organization was invited. Oka Town Ward Chairmen were invited. Youth was also invited. Students Organization was invited. And then the DC has taken a decision in order to control the law and order situation, that 2 timings were given to the 3 churches. Whoever wants to remain with the independent, then they should be worship in 1 timing. And believers who wants to join, still want to join in the main church, they were allowed to worship in 1 timing. So in short, 2 church timings were fixed by the Deputy Commissioner. That was in the month of February 2021. I think, if I remember correctly, it was on 12 February 2021. Now, agreed by that, the Oka Town Baptist Church and also the Committee of Legal Seal of Oka Town Baptist Church, they filed a writ petition before this Honorable Court. In that petition, the grounds taken were: 1, DC's order has deprived the right to worship. That is the violation of provisions of the Constitution under Part 3, Article 25(6), right to worship and all this. That is 1. And the other is, DC's order has deprived them to worship, right to worship. That is 1. And the other is, that is basically the main point. So to file the writ petition. Interim order was passed, suspending the deputy commissioner's order. So notice was issued to the parties. The three churches were served notice. In the writ petition, the parties were three churches. That time, it was not independent, not recognition was not done. So the parties were three churches. I'm not naming the parties in short for understanding. And writ petition was contested by filing affidavit in opposition by all the three churches. And then an order was passed by this honorable court. No, before that, before the hearing took place, the Luther Baptist Churches Association, they have recognized the three churches as independent churches under Luther Baptist Churches Association. So most of the tribes, they have the Baptist Churches Association. In respect of Aus, we have Au Baptist Arokomongtang. That means Au Baptist Church Association. Like that, the Luthers has got Luther Baptist Churches Association. That is the highest and apex church organization among the believers of the Baptist churches. So they are controlling the Luther Baptist churches. It's under the umbrella of Luther Town Baptist Church. So Luther Baptist Church Council has recognized the three independent churches as independent. Now, after that recognition, this honorable court took up the writ petition for hearing the case. During the hearing, since it was with regard to the granting of independent status or not, I made a submission before the honorable court that, look, during the pendency of this writ petition in the month of August, we have been recognized by the Luther Baptist Churches Association as independent churches. Therefore, in view of that, the writ petition may be disposed of, closed. Since we were already granted independent churches, we will be worshiping in our own churches. So this writ petition may be disposed of. However, the keys of the churches are in the custody of the deputy commissioner. Therefore, the deputy commissioner may be directed.
Disposal was before the notification of the deputy commissioner, dividing two times. Disposal of the case by the High Court.
After.
Okay, after.
Now, at the time of disposal of the writ petition, this honorable court has directed the deputy commissioner to hand over the keys to the three independent churches. And on the day of passing the order, this honorable court has put the pointed query to the council representing the main church, Okatan Baptist Church. My learned friend was not there. Another council was representing that time. So he also fairly considered the yes, they have been recognized as an independent church. So there is no issue on this. So it was a consensus order passed by this honorable court that the keys of since in view of recognition as independent churches to the three churches, keys which is in the custody of the deputy commissioner should be released to the three churches. That was the order passed by the honorable court. After that order, the petitioners, the present petitioners, three churches, approached the Deputy Commissioner with the order of passed by this Honorable Court. Look, Honorable High Court has directed to hand over the keys of the churches. So please hand over the keys to us. Accordingly, in due compliance of the order passed by this Honorable Court, the Deputy Commissioner has handed over the keys of the churches. Issue was normal by then. What happened? After 2 days of handing over of the keys to the 3 churches, the convener of the legal seal of Okaton Baptist Church, he submitted an application to the Deputy Commissioner, stating that, look, the keys of the churches mentioned by the High Court is only the keys of the church building. It do not include apartment keys, Sunday school keys, pastors' quarters keys. Other keys are not included. It says only about the keys of the churches. So please retrieve all the keys of other keys other than the church keys. That was the representation submitted by the convener of the legal seal of the Okatan Baptist Church. Here, the Deputy Commissioner, when he released the keys of the churches, it was a punch in the respective 3 churches, pursuant to the High Court order. I am releasing the keys of the churches. With that, he has released the keys. But then confusion arose because of the representation filed by the convener of the legal seal of the Okatan Baptist Church. By twisting and interpreting the order passed by this Honorable Court, he has invented a new theory that keys of the churches do not include other keys. This Honorable Court has never said anything about other keys of the churches, because to function the church, pastor is required. To function the church, Sunday schools are required. All properties are there with the church. So, pursuant to the direction passed by the High Court, the Deputy Commissioner has released the keys of the churches. But after 2 days, when the representation was submitted by the convener of the legal seal, DC got confused and maybe he was influenced. So he issued an order. Oh, the keys of the churches is only pertaining to the church building key. So you please return all other keys. This is a time when there was a virtual law and order problem in Okadam, particularly in the vicinity of the 3 independent churches. There was high tension. Police personnel were also summoned from Dimapur even. And then there was law and order problem. In view of that, the present petitioners, we were compelled to file an application before this Honorable Court by way of a review petition. Look, this Honorable Court, while first disposing the writ petition, has passed an order directing the Deputy Commissioner to release the keys of the churches. Pursuant to the order passed by this Honorable Court, keys have been released by you. And now, only after receiving a representation from the convener of the legal seal, you are trying to retrieve the keys. What is this? Pursuant to the court order, you have already released. But now, basing on the representation, you are again trying to retrieve the keys. This is how there is a virtual law and order problem. So, kindly clarify this. What is the real intent of the order to release the keys of the churches? While deciding the review petition, this Honorable Court, in categorical terms, laid down that keys of the churches includes all the keys, including property, all these apartment keys, it includes all the keys. So clarified, even after passing the order, DC was not inclined to release the keys until and unless she see the order. Lordship is well aware, after passing the order by this honorable court, some time is taken to obtain the CDC. Unless I see the CDC with my own eyes, I will not release. But the situation was getting very tense that day. So ultimately, we managed to somehow get the order around 4:30 p.m. in the evening. After sending that only, the DC has released the case. The present case is arising from that order by which the review application was disposed of. How? While disposing of the review application, an observation was made by this honorable court that with regard to the properties of the churches, issue was raised by the petitioner. We were the respondent in the writ petition. The present respondents were the writ petitioner, initial petitioner. They were mentioning about the properties and all these things. So this honorable court made an observation that, look, this forum, this court is not the right forum to decide which property should belong to whom, belong to whom. So if the parties wants to adjudicate about the property of the churches, then they may file, parties may file appropriate suit in appropriate forum. That is the categorical finding and order passed by this honorable court. Taking advantage of that order, the present respondents, they found and they may have realized that, oh, we got our opinion now. And then they file a suit before District Judge Oka, claiming property of the three churches that it belongs to Okatown Baptist Church. That is the suit which is filed. That is suit number, civil suit 1 of 2023. Now, as I was mentioning, initially, Okatown Baptist Church has been started by all the believers in the town. The properties which is holding by, possessing by Okatown Baptist Church are developed by all the believers, including the three independent churches. It's a property of everyone, all the believers as church. So also the properties, the buildings which are constructed, the other properties which are with the three churches are also jointly developed by all. The present Okatown Baptist Church properties are created by all the believers. So also the properties belonging to the three independent churches have also been developed by all the believers. So in other words, all the properties belongs to all the believers. That was the situation and position. Now, by filing the suit, do you want to get a declaration from the court that all the properties belongs to Okatown Baptist Church only, and the three churches are not the owners of this property? And in the suit, while filing the suit, they have met the non-joindera parties, misjoindera parties. There were a lot of technical defects. So the present petitioner, we file a application under Order 7, Rule 11 of the CBC for rejection of the plaint. That look, this plane is not maintainable, so it is liable to be rejected. Because parties are also not appropriately implemented, joined a party and non-joined a party. So many defects are there. So this petition should be dismissed. Suit should be dismissed. That was the prayer. But then that application filed under Order 7, Roll 11 was rejected on the ground that misjoinder and non-joinder party cannot be a ground to dismiss the suit, plaintiff. So that is okay. Now, after that, we filed the present IA, miscellaneous application, that is under Order 1, Rule 10, particularly Clause 2 of CPC. And as per the provisions of law, the court has the power to add or to delete any party during the proceeding of the case. So, in view of this provision, we file the IA on the ground that, look, in the suit, you have implemented 3 individuals as party representing the 3 independent churches. That is not proper, because this is with regard to the declaration of title on a property. The church is the owner of the property. And I'm only an individual, so I cannot represent the church. First, they should implement the church as a party, and thereafter, who should represent, that is another issue. Now, while disposing of the review petition by this honorable court, the observation passed by this honorable court is the parties, who are the parties? Parties may initiate file appropriate suit before appropriate forum. The parties, who are the parties before the High Court? That is important. Okadon Baptist Church was one of the parties. They were the respondent in the review application. 3 churches were the petitioner in the review petition, not the individuals who they have implemented now in the suit. They were not the party. They were only the representative of the church until authorization by the church only. And it is the discretion and prerogative of the church who should represent the church. If there is a statute, if there is a rule, if there is a memorandum of association or article of association stating who should represent the church, that is one aspect. Such things are not there. So, the court is compelling the parties to represent the church. Who should represent? Neither the petitioner, the plaintiff, nor the court can pass an order and issue a direction who should represent the churches. And all litigations, starting from the writ petition filed by the present respondent and the review application which was filed before this honorable court, in all the proceedings, the parties were the Okadon Baptist Church was one party, and the 3 churches were the parties, not the individual persons who they have implemented now. They are trying to say that individual persons are representing the church. It is not they who can direct who should represent the church. So, the application filed under Order 1, Rule 10, Clause 2 is, I'm not the right person in the case. The direction of this honorable court in the review application was parties to the suit, parties to the case. So the relevant point is, who are the parties in the case? Okadam and the three independent churches were the parties in the case. Therefore, without clearing this legal position, if the suit is proceeded further, there will be a problem. Ultimately, a day may come for the court to pass a decree in favor of some particular party. We have raised an objection also among the plaintiffs. There are two plaintiffs here. One is in the individual capacity. What amount of, what percentage of property he is holding, what percentage of property should be given to that individual person, which belongs to the church, I don't know. But then it was filed by two persons. One is church and the other is one individual person. That is the convener of the legal suit. So he has filed in the individual capacity. So in the event of passing any decree by the court, ultimately, up to the entire trial is commenced. Then, how, under what situation, the title will be declared in favor of the plaintiff number 2. That is also one aspect which is disturbing my mind also. Now, while deciding the case, the present IA, the court, the district judge, learned district judge, the court arrived to a finding that church is not a juristic person, so it cannot be the party. That is one. Accepting that reasoning, okay, if that is correct, Oka Town Baptist Church is not a juristic person, then the plaintiff number 1. Accepting the finding of the court, but the court has totally ignored that aspect. If we as independent church is not a juristic person, accepting the argument, the reasoning, then the plaintiff number 1 is also not a juristic person. Then in what capacity he can file? She can file a suit. That is one. Second reasoning arrived by the court below is, in the review petition, it was represented by 3 individuals. Therefore, they should represent even here also. That was the finding. Now, in the review, it is that finding is totally wrong, not correct. Why and how? See the order passed in the review and see the cause title. Who are the parties? Because the order of this honorable court is very clear that the parties in the case. So who are the parties? Can we come to page 118? Has your lordship got it?
Yes.
Shamayan Baptist Ekamko, that is Baptist Church, and 2 others. And then Supayancha Baptist Ekamko. Number 3, Techan Lota Baptist Church Ekamko. These are the parties. So, even in the suit, this should be the proper party. And respondents, Mr. Orumbo Hamtur and 6 others, and names are given. The Deputy Commissioner, Okadon Baptist Church is respondent number 4 in the review. But we are concerned with 1, 2, and 3. Who are the parties? These are the parties. This 1, 2, 3 are the petitioners here now, not the church. They should have met these 3 parties as party respondent. And kindly see the direction and order passed by this honorable court also, page 140. I will take your lordship's attention only to the relevant portions. page 140. Paragraph 11, bottom of the page. That's your lordship got it. May I read, lordship?
Yes.
As stated above, in any case, this court is not the right forum to decide regarding the rights and title of the parties over the properties at this stage. They must first be decided by the civil court, having geographical and pecuniary jurisdiction as already stated. If the prayer of the petitioner in the review petition is considered and allowed, it would amount to stepping into the shoes of a civil court. It would also amount to do something indirectly which cannot be done directly. As such, precisely stating, the parties will have to approach a civil court of confidence having jurisdiction to decide their disputes over the properties. Now, who the parties to the suit petition, parties to the case, who are the parties? I have shown to your lordship who are the parties. Parties were the 3 churches, and 3 individuals were not the parties in that case. So the direction of this honorable court in the review petition is to file an appropriate suit. Parties were given at liberty. I may have filed, now that they have filed. If from our side, if it is filed, the 3 churches will file, not the present individuals who are included as the defendant number 1, 2, and 3. So the finding arrived by the learned district judge, learned court below, is not in terms of the order passed in the review application. And again, lordship, to just satisfy lordship and the parties again, kindly come to page 25, annexure A. Where they have gone wrong. I have just shown to your lordship who are the parties in the case. And in the suit, in the matter of number 1, Accordon Baptist Church, through its board of deacons. See, I feel that it is proper, represented by secretary, Mr. So-and-so. Number 2, Mr. Warumbu Mahamudri, convener legal cell committee, Ukatan Baptist Church, Ukatan district. So, in this manner, the respondents, the defendants would have been met in the suit. 3 churches, as is shown in the review application. So, lordship has said, who were the parties in the review? And then kindly see the defendant, page 26.
You are aggrieved by
I am aggrieved by implementing me as a party respondent here.
respondent number 1, 2, 3.
Yes.
So, but they are representing the church.
Yes. How can I represent the church? Court, this honorable court said that parties may file appropriate suit. Who were the parties in the case? That is why I am referring to page 118. See the order. What order was passed by this honorable court?
Sumyang Bapuch.
Church should be met the
Okay.
party.
Who represent the church? So,
Church should nominate
Sumyan
a person.
Baptist Ekumko.
Yes,
Who represent this church?
church should represent.
Okay, and church is represented by
The petitioner, present petitioner, in the individual capacity until authorization by the church. Now, you should have embedded this church as party respondent so that after getting notice by the church, who should represent the church should nominate. It is neither the plaintiff nor the court who should represent the church. Because the parties before this honorable court were the churches, not individuals. Therefore, in the suit, the church should be made a party and church should decide who should represent in the case, not by the plaintiff nor by the court. What authority they will have so as to take a decision to represent the church. That is the whole issue.
Normally,
Misconception went there.
normally say, for example,
Yes,
Samian Baptist Ikomko,
yes.
who represent this church normally anywhere?
Actually, it should be pastor or the board of deacons who should represent. Like that, the Okatan Baptist Church has been represented by the board of deacons.
Anyone authorized by the church?
Yes. Who should authorize that? After getting the copy, now that Shamia Baptist Ikomko is implemented as a party defendant, notice will go definitely. After getting the notice, the church should decide, oh, we have received a case against us, so who should represent
Okay.
on behalf of the church? That decision should be taken by the church itself, not by the plaintiff nor by the court. Church is an independent body. Church should take a decision who should represent the church. Had there been any role in a memorandum of association, who should represent the church, then it has to go as per that. But in absence of any such provisions, then after getting the notice by the church should nominate a person. It may be me also, no problem. So long as the church nominates me and appoint me and authorize me, I can represent the church, no problem. That is how I have also represented until authorization.
In a
by the
review,
church.
in the review, who represented this Samian Baptist Ikomko?
The petitioner.
The petitioner until authorization by the church.
Okay.
So.
And then same with the
Same with the other two churches.
the respondent two
same
and
with the other.
some other also.
Yes.
And accordingly, in the suit, they have implemented the
Yes, as representing the churches.
representing the church.
Yes, that is wrong.
So according to you, that is wrong
Yes. Why it is wrong?
because they represented in the review petition.
Only for that particular case you were authorized to represent before the High Court.
The proceedings.
That is not
review.
automatic. That proceeding is already closed.
Okay.
In the High Court, yes, I have been authorized.
Now, are they no longer the sumo representing? Are they no longer the member of that?
They are.
Or they are?
We are, and they will be, but not
Okay.
yet.
They are and they will be.
Even now,
Then,
even tomorrow.
hmm.
If the church appoints me, authorize me
Hmm.
to represent the church, I'll be the happiest person to represent the church.
Okay.
But the plaintiff themselves are tracking me and that you should represent the church. Can they take a decision?
Now, since you have already represented
No.
the review petition
Close.
closed,
In the same manner.
based on that, probably this petition was
That
filed.
is why
Hmm.
that is misconception.
Okay.
There the whole problem arose.
Okay.
Wrong conception. Just because I have represented in this until authorization in this particular proceeding, and once this proceeding is closed, can that authorization will still remain somewhere else next year, after 10 years?
And then this Sumongo Obong, in
Yes.
what capacity he is there in the church?
He is a believer in the church, he is a member of the church.
Hmm.
Therefore, church will nominate a person to represent them on whom they have confidence to represent the church. And that decision will be taken by the church only, that particular church,
Then in that
not
case,
by others.
in that case, then in order to file suit against the church, the person has to ask church who are going to represent.
That's why I'm referring to the order passed by this honorable court.
Hmm.
The parties
Ah,
were
right.
given liberty to file suit.
Hmm.
It may be me, it may be thee.
Now, probably immediately the parties are these person only
Yes.
representing the church?
In the High Court,
Hmm.
that is not disputed at all.
Hmm.
I have represented the church until authorization in this particular proceeding. The moment this particular proceeding is closed, this clause is no longer pending. So my authorization also comes to an end along with the closure of the case.
Now, unless the church is being represented by any person, then how the
Sorry,
notice?
Lordship.
Hmm.
That is why
Hmm.
they should have made the church as a party
Hmm.
and notice will go to the church. After getting the notice by the church will take a decision.
Someone has to be
They
there
will
to
have
accept the
meeting.
notice. Someone has
Yes.
to be there to accept the notice. Hmm.
They will have a meeting. Who we should authorize to represent the church.
Okay.
That is what it was done in the writ petition and also in the review. Until authorization, I can represent. Even tomorrow also, if the plaintiff change their cost heading, file an application, and Chamayan Baptist Sekamku is made as a party, then after getting the notice, Chamayan Baptist Sekamku will take a decision. Who should represent? We have received a order from the court. Who should represent the church? Church will take a decision. That is my case. To represent the church, the plaintiff cannot take a decision. They are a stranger. The court is all cannot say that so and so should come and represent. They are forcefully pulling somebody from the street and then trying to represent the church. Can that be? That is not the law. Lordship, I will just cite an example.
Yes.
Government, when the case is filed, mostly we are burdened with the government cases. So and so versus the state of Nagaland, represented by the chief secretary or anybody.
Yes.
But it is not the chief secretary who will come and swear the affidavit.
No, that is different.
One under secretary will be authorized by the government.
Chief secretary is clear. The chief secretary has the name and designation.
Yes.
Hmm.
So like government will be represented by the commissioner and secretary.
Hmm. So
They will-
here also, church represented by, like the government of Nagaland, represented by chief secretary. So church represented by someone has to be there.
Yes, somebody has to be there, but the party should be the church. But in the suit.
So
they have
here
not
also,
made
here
the-
also it appears as representing the Sumian Baptist Church.
Yes.
Okay, you mean to say that Sumian
Sure.
Baptist Ekomko represented by Mr. So and so, you want? Okay,
Lordship has come to-
it's all the same, isn't,
No,
not the
it
same.
is not same.
Okay,
It is not same. How can I
Okay.
be the church?
right. Hmm.
And in the review, this honorable court clearly said that the
Yes.
parties to the case. So who are the parties? See in the review. Parties are the three churches. So in the suit,
Yes, it is the person who represent the church.
yes,
Okay,
in that proceeding,
so only the, of course,
by way of filing an affidavit only. But party is the church. He was only asked to swear the affidavit.
person may change.
Yeah. Person may change, but church will remain the same. Tomorrow I may die. Another person will come and represent. But church, it's a perpetual body. Till the Christ comes. It's a very simple, but where it has gone wrong. The very conception was wrong. And what is the problem of impleading the church as a party respondent? Let them implead and it will go to the church. Church will take a decision who should represent the church, and accordingly the case will be proceeded. Let us set the things in order and then proceed with the suit. That is what. we
What is,
want.
what is your
In
prayer
accordance with
here?
law.
What is your prayer here?
That they should be deleted. The name should be deleted.
Name should be.
Name should be deleted.
And proper party should be in there.
So according to you, the church should be The party represented by the
Yes.
person, if there is any.
Only the church will be made party. And church will contest the case to file an affidavit, to swear an affidavit, to nominate somebody. That is what we have done in the review. In the review application also, I am not the party, but I have sworn the affidavit representing the church. Because somebody has to represent. Similarly, in the suit also, they should implement the church as a party so that the church will decide who should represent the church. Very simple. But a theory has been created by the learned court fellow, and look, since you have represented in the review application, you should be a proper party. That proceeding has already been closed, number one. Number two, in that case, I was not the party. The church was the party. So even in the suit, the church should be a party.
Now, since you represented in the review petition, your name would be there. Shaman Baptist Ikomko, represented by Sumongo Abong.
Wrongly they have embladed, that is why we are asking that, look, this is wrongly embladed, you emblade the church, you delete me. How they can dictate me to represent the church?
So by the impugn order, your prayer was
Rejected.
rejected. Okay. So that is your prayer.
Can you come to page 187 again?
187. 187.
Yes, 189.
Yes.
189. An application. 189. An application under order 1, rule 10, clause 2 of the CPC. For leave to implement Reverend N.L. Pithan, Reverend Pachumo Pithan, and Reverend S. Ulo Izan as the defendants numbers 8, 9, and 10 in the civil suit 1 of 2023. So this is an application that these people wants to represent the church. And this application is pending also.
This IA is pending.
Your Lordship, during the pendency of the civil suit, we came to know about certain church members who had been made pastors and the board of deacons. So just to offset this kind of objections being put up again and again, we submitted an application for impleadment of these persons as party respondents, party defendants. So that has been allowed. That has been allowed. Because of the stay which has been granted to your Lordship, even the stay operates against these newly implemented defendants also. I mean, no, since April 2023, the suit has not progressed. One application after the other filed by the defendants.
No, it has to be in the proper form. Otherwise, again, in the halfway through the complications. That's why before proceeding further, all these technicalities has to be overcome. Again, Lordship, can you come to page 141? One for one.
Yes, what is
Fifth
that?
line from the top.
Yes.
The sentence starts with as such. As such, precisely stating. So in short.
This is what, this is order.
Yes.
It is.
This is the order passed in the review.
In the review application.
Okay, okay.
The parties. The parties. Who are the parties? Will have to approach a civil court of confidence having jurisdiction to decide their disputes over the premises. So the parties this honorable court said the parties.
Yes, it again would mean that the parties, like the church represented by you, since you have already represented.
Court said 118,
Yes,
118.
118.
Who are the parties? In the review.
Okay.
1, 2, and 3. These are the three judges, they are the parties. Who are the petitioners here?
Hmm.
The individuals are the petitioners here because they want to delete their names. This should be the parties. A notice should go to them.
You are only agree by the person having been named,
Yes.
okay, impleaded as a party.
Yes.
And then it should be represented by they should implead the church, not the
Yes.
person.
Yes.
Okay.
Because in the
Anything else?
review also,
Hmm.
the three churches were the parties.
Hmm.
In the writ petition also, three churches were the parties. And the present suit is a continuation of the earlier proceedings.
Hmm.
So church was a party all along. Therefore, even in the suit, the church should be a party. Because the property belongs to the church, not belong to the individual. And even in the event of passing a decree, it will be in favor of the church. Because church is the owner of the property, not the individual. But church cannot speak. So somebody has to be nominated and entrusted and authorized to speak on behalf of the church. That is why church should be made a party and church should nominate and appoint and authorize who should represent the church. And it is not a plaintiff who should dictate me or who should represent the church. Just pulling somebody from the street and then you represent this church. Can that be? We are against that. No.
So you mean to say that they may or may not represent the church?
Yes. Tomorrow the church may decide another person to represent the church. In the review petition and in the writ petition, we have been authorized. Maybe the church has confidence on me to represent the church. Similarly, in the civil suit also, they should have met the church as the party so that the church will nominate somebody to represent the church. But the name of the court title will be same, church. It will be white in the name of the church, but somebody has to sign the affidavit. So church has to nominate somebody to whom they have confidence.
So,
Yes, madam.
anything else? Mr. Yeah. Anything else? That's the only prayer.
And I would like to set one judgment.
Okay.
Proper party. This is 2000. 2010 7 ACC. Or 1 7. I will just take your lordship's attention to 4 paragraphs only.
Paragraph.
Paragraph 13.
Yes.
Here it is. This is on order 1, row 10, clause 2.
Para 1-3.
Para, yes, 13, the last
Yeah,
paragraph.
yes.
The general rule in regard to impleadment of parties is that the plaintiff in a suit, being dominus litis, may choose the persons against whom he wishes to litigate and cannot be compelled to sue a person against whom he does not seek any relief. Consequently, a person who is not a party has no right to be impleaded against the wishes of the plaintiff. But this general rule is subject to the provisions of Order 1, Rule 10, Clause 2 of the Civil Procedure Code, which provides for impleadment of proper or necessary parties. The said sub-rule is extracted below. Rule 10, Clause 2. Court may strike out or add parties. The court may, at any stage of the proceedings, either upon or without the application of either party, and on such terms as may appear to the court to be just, order that the name of any party improperly joined, whether as plaintiff or defendant, be struck out, and that the name of any person who sought to have been joined, whether as plaintiff or defendant, or whose presence before the court may be necessary in order to enable the court effectually and completely to adjudicate upon the title, upon and settle all the questions involved in the suit, be added. 14. The said provisions makes it clear that a court may, at any stage of the proceedings, including suits for specific performance, either upon or without any application, and on such terms as may appear to be just, direct that any of the following persons may be added as a party: a person who ought to have been joined as plaintiff or defendant, but not added, or any person whose presence before the court may be necessary in order to enable the court to effectively and completely adjudicate upon and settle the questions involved in the suit. In short, the court is given the discretion to add as a party any person who is found to be a necessary party or proper party. 15. A necessary party is a person who ought to have been joined as a party and in whose absence no effective decree could be passed at all by the court. If a necessary party is not impleaded, the suit itself is liable to be dismissed. A proper party is a party who do not have necessary party is a person whose presence would enable the court to completely, effectively, and adequately adjudicate upon all matters in dispute in the suit. 2. He need not be a person in favor of or against whom the decree is to be made. If a person is not found to be a proper or necessary party, the court has no jurisdiction to implead him against the wishes of the plaintiff. The fact that a person is likely to secure a right interest in a suit property after the suit is decided against the plaintiff will not make such persons a necessary party or a proper party to the suit for specific purpose. Paragraph 16 is also relevant, but then the paragraph 15 is very clear that the dispute here in our case is pertaining to the property of the church. The suit itself is claiming the property. Now, I'm an individual person. The property is owned by the church. Therefore, the three churches are the proper parties in the suit. Representation can be by anybody. If they nominate me, I can represent. They may nominate another person. Such authorized person may represent the case. And if the title is to be declared, can it be declared in my name? No. I'm not the owner of the property. Church is the owner. Therefore, it is the church who should be impleaded as a party respondent, defendant, and the petitioner should be deleted. The defendant should be deleted from the as one of the defendants in the case because I have no authority to represent the church unless I am authorized by the church. And in the review application, the parties to the case were the churches, not the individuals.
Okay.
Yes,
Like,
Yes.
may I please, Your Lordship.
Yes, please.
Your Lordship, the key phrase in this case is representative capacity. Representative capacity. It is a key phrase. It is a phrase which is well recognized in jurisprudence. Representative capacity. Now, Your Lordship, facts have been stated by my learned friend on the other side, but the facts are not correct. Wokaton Baptist Church established 3 churches in the Wokaton area in 3 colonies. Industry Colony, Saron Colony, Wungoji Colony. 3 churches, the properties of which were procured, purchased, established, constructed by the Wokaton Baptist Church for the believers in these 3 colonies. Wokaton Baptist Church is the mother church. Wokaton Baptist Church is the parent church. How Wokaton Baptist Church chooses to dispose of its property, it is the exclusive domain of the Wokaton Baptist Church. Not by any member of the congregation. Not by any member of the 3 churches. So what happened here, my lord, is that in these 3 colony churches, some persons came out with the idea that they should have separate churches, they should delink from the mother church. Now, the congregations in these 3 churches were also not unanimous in that view, as already admitted by my learned friend. Some persons wish to remain with the mother church. Some persons wish to become an independent church. So they adopted a very novel method to separate from the mother church. They changed the name of the churches. Wungojo Sector Church, NSS Sector Church, Saron Sector Church. They changed the names of the 3 churches into the names mentioned in the petitions filed by them. A dispute arose between the parties. Deputy Commissioner stepped in, and Deputy Commissioner said, taking note of the fact that the congregation itself was divided in these 3 churches, set 2 timings for both factions. One faction which wanted to remain with the mother church, one faction which wanted to separate and stay with the separate and form a new church. Lothar Baptist Church Association stepped in. Lothar Baptist Church Association said, yes, if you want to separate, you can separate, but you cannot take the properties of Wokaton Baptist Church. Your Lordship will see that in page 171 in the petition filed by the petitioners, page 171. Has Your Lordship got 171?
Yes.
171. It is in the Lotha language. The English translation is at page 173. 173.
Yes.
Then I cannot take which page, which election. It is sorry, my lord, this is not 171. This is a different one. In the interim model passed by. Your Lordship, before that, in the writ petition which was filed, if I may take Your Lordship to the array of parties, Your Lordship will find that in 107, page number 107. Page 107.
Yes.
The array of parties is 1, Mr. Such and such, the convener of the legal cell, and 2 and 3 are members of the legal cell. These were persons who were authorized by the Wokaton Baptist Church to file a case. And then Wokaton Baptist Church itself, at serial number 4, if your Lordship can come to that.
Yes.
Wokaton Baptist Church, Wokaton, etc., represented by its convener. Representative capacity. Representative capacity. This is the key phrase with which I began my arguments here. Representative capacity. Now, for us we did not know who are the key persons representing the three churches. So we put down the names, 4, 5, and 6. 4, 5, and 6. That, my lord, if I may say at this point of time, it was an error on our part not to have someone represent these churches. Just by mentioning the churches alone, that was a defect in our part. They did not object to this defect. They entered into appearance by the three petitioners in these three separate petitions. They entered into the picture. And they secured an order, Your Lordship. The order dated 16/9/2021. Firstly, the Lotha Baptist Churches Association said, if you want to separate, you can be separate. This was followed by another letter. And in that letter, the Lotha Baptist Churches Association said, you can separate, but you cannot take the properties of Wokaton Baptist Church. But firstly, the most important point of note is this. The Lotha Baptist Churches Association is an association of churches. It is just an umbrella body. The association by itself has no authority to interfere in the functioning of individual churches. Your Lordship is aware of the functioning of churches in the Northeastern region. There is just an umbrella body, an association of churches which comes together for the benefit of all the churches. So the Lotha Baptist Churches Association, apart from the fact that it has no authority to dispense the properties of the individual churches, it said, you can separate, but you cannot take the properties of Wokaton Baptist Church. During the pendency of the writ petition, the Lotha Baptist Churches Association, without consulting the Wokaton Baptist Church, this is very important, Your Lordship, without consulting the Wokaton Baptist Church, issued a letter recognizing these three churches. That is it. Just a letter saying that the Lotha Baptist Churches Association recognizes these three separate churches. Whether Wokaton Baptist Church actually allowed them to separate or not, that was not an issue. That was not even considered. For us, as Wokaton Baptist Church, we say the letter of the Lotha Baptist Churches Association is immaterial. It has no value at all. Unless we allow the churches to separate, they cannot separate. Unless we allow these three colony churches independent status, they cannot become independent. They are members of our congregation, Your Lordship. We are the mother church. We are the parent church. That is our stand. Now, during the pendency of the writ petition, the petitioners, they come out with a very novel approach again. They said, we now have our own churches. We now have our own churches. And so we will worship in our own separate churches. For us as Wokaton Baptist Church, if they say they have their own churches, who are we to object? We have not given our churches to them. All these properties still, till today, Your Lordship, all these properties still stand in the name of Wokaton Baptist Church. Regardless of the fact that they have very conveniently, surreptitiously changed the name of these churches. If I change the name of Arunachal Pradesh to Nagaland, Your Lordship, does it become Nagaland? It is still Arunachal Pradesh. Ridiculous, my lord. Ridiculous. This is the strategy that they adopted. They changed the name of the churches and they said that they have their own churches. But for us, if they said that they have their own separate churches, we were not there to object. We were really under the impression that they had their own separate churches. And the direction of this Honorable Court in disposing the writ petition was not to give the keys to the petitioners to the three churches. The keys were seized, our keys were seized by the Deputy Commissioner. They claimed to have their own churches. So this Honorable Court said, give the keys of the church to the respective churches. Not to them, respective churches. So we have our own churches. The keys should have come to us. But even amongst our own people, understanding was not quite right. There again, we were at fault. The keys were handed over to the keys of the churches. Were handed over, the keys of the churches and the keys of all the properties attached to these churches were given to the petitioners, to the three churches. We objected. Of course, as I was submitting earlier, Your Lordship, there was a misunderstanding on our part also. We thought that the keys of our churches should be given to them. That was a fault on our part. They filed a review application. And what was stated in the review application, Your Lordship? What was stated in the review application? Your Lordship will find that. It is very interesting. And I have reproduced that in my written objection in the earlier application which they filed for rejection of my plaint. Your Lordship will find that at page 156. Page 156. And the relevant portions at page 163. What they stated in the review application as today's status before this honorable court. At paragraph 9.
156 is.
163, my lord, 163.
This is a misapplication
Yes, my lord.
before the.
Yes, this is my written objection to the first miscellaneous application filed by them for rejection of my plane under order 7/11.
Okay. Relevant is 150,
163.
163.
At paragraph 9.
Yes,
May I read the paragraph, Your Lordship?
yes.
Paragraph 9. That with regard to the statements in paragraphs 1 and 7 of the application, as stated earlier, Mr. Sumongo Ovang, the applicant defendant number 1, that is the petitioner in the instant petition, held himself out to be an authorized representative of the Wungoju Sector Church, now which they call the Samian Baptist Church. The statement in this regard can be seen in paragraph 2 of the petition in Civil Review Petition number 3/2021. The said paragraph is reproduced hereunder. That the applicant number 1 is the Samian Baptist Ekumko, Wungoju, represented by Mr. Sumongo Ovang. Applicant number 2, that is the petition in the other petition, Chupayangza Baptist Ekumko, NSC Colony, is represented by Mr. Vian Paso. And the applicant number 3, Tichan Lotha Baptist Ekumko, is represented by Mr. Mutsang Muli. The applicant number 1 is Advisor Action Committee, not just a mere member, Your Lordship. All misrepresentations are being made before this honorable court. The applicant number 1 is Advisor Action Committee, 3 churches. He himself actually could represent all the 3 churches. The applicant number 2 is the Convener Action Committee, 3 churches. And the applicant number 3 is the Secretary of the 3 churches. These are not mere members, Your Lordship. All the applicants were authorized by the 3 churches to file the instant review application and to take any steps for redressal of the grievances of the 3 churches. And on their behalf, all the applicants have a common cause of action and grievances, and as such, the applicants are filing the instant review application jointly. So here, Your Lordship, is a first statement, a categorical statement that the 3 applicants were representing the 3 churches in a representative capacity. This honorable court has also taken note of the fact that the writ petitioner as well as the respondents, including the respondents, are before this honorable court in a representative capacity. So the representative capacity is established. That is the first point I would like to make, Your Lordship. Representative capacity is established. Now, how did the London District Judge dispose of this application? Your Lordship, the first order is at page 175. 175. At page 175.
What is this?
This is the order by which the IA for the rejection of the plane was dismissed.
Okay.
And this is an order dated.
This is impugn order.
No. This is the first order
First one.
by which the application for rejection of the plane was dismissed.
Okay.
Against this, they came by way of revision, Your Lordship. That was withdrawn by them. The withdrawal date, Your Lordship, the order should be somewhere on record. IA number and date, IA number 16 of 2023. Civil revision number 16 of 2023. Again, the challenge to this order was withdrawn. Now, the relevant portions at paragraph 23 and 24. And 24. Page 185.
Hmm.
23, 24, yeah.
Hmm.
Your Lordship has got that?
Yes.
The second issue raised is impleading persons in individual. The same plea which is being raised today, Your Lordship. Defendants 1, 2, and 3 suffers from misjoinder of parties and further impeding an individual plaintiff 02. So they are attacking even the individual plaintiff who sworn and signed in the affidavits and verification in the plaint is not a necessary party. 24. It is seen that this is not a ground for rejection, and these are the same parties who in civil review petition 3 of 21 were allowed to approach a court of competence having jurisdiction to decide the dispute over the properties by the Honorable High Court. Considering the pleading made in the plaint, the relevant documents enclosed along with the plaint and submissions made by parties, it is seen that a serious question of law and facts are involved in the suit and at hand, which requires detailed consideration. Under these circumstances, this court is not inclined to pass orders rejecting their first civil suit. So the grounds raised by them was rejected. The same grounds which are being raised in this instant petition. The another trial court found that these are the same parties. Same parties. And much has been said made by my learned friend that their representative capacity included detailed the disposal of the review application. In the review application, this honorable court allowed the parties to the dispute to approach the civil court. Who were the parties at that time? The Walkathon Baptist Church, represented by the person's name. The three churches, represented by the person's name. They were still parties. It is not as if they vanished from consideration in the disposal of the review application. They were parties. They were parties. That is why I keep on harping on this phrase, Your Lordship, representative capacity. So the ground which was taken by them, the ground which is now again being repeated, has already been considered in this case also. They filed a revision petition against this, and they withdrew the revision petition. This decision of the learned district judge still stands. This decision of the learned single judge still stands. Then, Your Lordship, the impugned order is at page 272. 272. Just certain paragraphs which are relevant for the purposes of this petition, Your Lordship.
Yes.
Page 276. Page 276.
Yes.
Paragraph 7, my lord.
Hmm.
This court, by order dated 27/9/23, had already decided the application filed under Order 7, Rule 11 by the present application defendants in civil case case 5, 6, and 7/23, whereby, amongst other grounds for rejection of plaint, the present applicant defendants also took the ground that the plaint filed in civil suit 1/23 suffered from misjoinder of parties, as the applicant's defendants were impleaded in his individual capacity. However, the ground taken by the applicant was rejected, and civil case number 5, 6, 7 were dismissed. Be that as it may. Then 8. As rightly pointed out by learned counsel for the opposite party, the Samayan Baptist Ekumko, etc., are not juristic entity, and as such, it has to be represented by its member. Is there any fault in this, my lord? Is there any fault? It is settled now. The church is not a juristic entity. My learned friend is arguing that the church has been impleaded or named as a plaintiff. The church itself cannot be named. It is not a juristic entity, Your Lordship. It must be represented by someone. The court has taken note of the fact that the churches, etc., was represented by the applicants at paragraph 9, Malan, was represented by the applicant defendants in civil review petition number 3 of 21. And further, it is also admitted by the applicant's defendants in the instant petition that they represented the three churches only in a representative capacity. So they also admit that they represented the three churches in a representative capacity. That is important, Your Lordship. Lordship may kindly note that. They represented the three churches in a representative capacity. Now, in the application which is filed by them, at page 213, at page 213,
Yes.
may I take Your Lordship to paragraph 5. This is their own statement, and this statement itself invalidates all the arguments raised by my learned friend in court today.
Yes.
That the applicant begs to state that the present applicant represented the Samayan Baptist Ekumko Wungjo only in representative capacity. What he says afterwards does not matter. Everything else stated in the application does not matter. What matters is the fact that this person represented the Samayan Baptist Ekumko in a representative capacity. That is the point I'm trying to make. And this is the substance of his application, Your Lordship. That he represented in a representative capacity. So in the suit, he is not entitled to represent the church in a representative capacity. That is his statement, unless authorized. That is the case, Your Lordship. Now, in my civil suit, which is at page 25, the array of parties, just for Your Lordship's satisfaction, at page 25. Again, Your Lordship may note, I am saying the Wokaton Baptist Church represented by a secretary. This is in a representative capacity. Then, next page, Your Lordship, Mr. Sumongo Ovong representing the Samayang Baptist Ekumko. So this is also in a representative capacity, not in an individual capacity, Your Lordship. It is in an individual capacity. If we are to indulge in semantics, Your Lordship, if you are indulge in language, the twist of language, the state of Nagaland represented by the Chief Secretary, or the Chief Secretary representing the state of Nagaland, isn't it the same, my lord? It is the same. And what have I said in my application, Your Lordship? In my application, the foundation, my lord, the foundation of this issue of representative capacity, Your Lordship may kindly note, the fact that the churches were being represented in a representative capacity from the writ proceeding to the civil review is an established fact. It is an established fact. There's no dispute with that anymore. So, what did I ask for in the plaintiff, Your Lordship? At page 28. If Your Lordship, you kindly come to page 28. That the plaintiffs in the instance suit are the Wokaton Baptist Church, hereinafter reported as the WBC, and representative of the said church. The WTBC, a congregation of the Baptist denomination, caters to the spiritual needs of the believers in Wokaton. The WTBC is represented in the instance suit through the Secretary of the Board of Deacons and convener of the Legal Cell Committee. So the convener of the Legal Cell Committee is also not appearing in his individual capacity. He is appearing as a representative. The plaintiffs crave the leave of this honorable court to be permitted to file an instance suit as representatives of the WTBC and also for themselves. Important here, Your Lordship. It has been filed, the suit has been filed in a representative capacity. Then paragraph 2. Would Your Lordship come to paragraph 2?
Yes.
That the defendants numbers 1, 2, and 3 are members of the congregation of the WTBC. They represent certain groups in the congregation who wish to break away from the WTBC. They have represented the interests of their groups in proceedings before the Honorable High Court in WTBC number 629 of 21, Civil Review 3 of 21, and Criminal Contempt Petition number 1 of 2022. The plaintiffs crave the leave of this Honorable Court to be permitted to file the instance suit against the defendants for themselves and for the group's members they represent. So this is also again in a representative capacity. Now, what is important, Your Lordship? In a representative capacity, a suit will be decreed. In favor of the person who is representing in the representative capacity, but it is not a declaration of title in respect of that person. And that's where the misconception is arising, Your Lordship. That is why we have the whole idea of a suit filed in a representative capacity. It is for the benefit of the whole, by one person who is representing the whole. That is the logic behind filing or defending on the basis of representative capacity. So it is very wrong to say that a suit for representative capacity cannot be filed. It cannot be represented by a single person, or it cannot be by name, by any person's name, representing the entire whole. That is a very misconceived notion. Now, what is the point as far as representative, what is the law on the point of representative capacity? Your Lordship, if I may take your order. Lordship to make notes.
Oh, Then I
At
think
two?
it will take at two.
At two, madam.
We'll resume at two.
Very well, madam.
Okay.
Ending na.
Itu ya senang biasa. Ini penting lah. Mau mati lah, deh. Mungkin tak sudah. Ini sudah yola.
Kimi kagene dikhe ki kagene. Kimi kagene dikhe aji kagene.
Mostly di mana? Already already mati di mana? तुम लोग मेंशन कर ले इधर हो स्टार्ट करा तुमने कैसे गई मेंशन उन्होंने चैनल से
The settlement. Yeah, but that is.
Wait, please, Lordship. Lordship, just to complete the facts, just a few minutes to complete the facts, my lord. Firstly, Your Lordship, at page 83. Page 83. My lord will recall that earlier I was mentioning about the Lotha Baptist Churches Association saying that you can be a separate church, but you cannot take the properties of the Bukatan Baptist Church. Page 83. This is the Lotha, this is in the Lotha language, and the translation is at page 84. Page 84.
Yes.
So this is addressed to the three churches. Your Lordship will find that.
Yes.
To the three churches. Subject request petition, respected church leaders. Greetings by the grace of God. Since you have separated and created an independent church from WTBC, you are not authorized to make use of any of the lands, buildings, properties of WTBC unless WTBC consents to willingly give you any properties from their possession. Now, at a time when the writ petition was filed, Your Lordship, an interim order was passed in our favor, saying that Your Lordship will recall the Deputy Commissioner's orders giving different timings to the different groups. So an interim order was passed in our favor. Against that, they filed an application for vacation of the stay. That was decided by the Honorable Court. Your Lordship will find that in page 100. Page 100. This is IA Civil 56 of 2021. And this is an order dated 3/8/21. And the relevant portion which I wish, which I take, to which I will refer your Lordship is at page 105. In the middle, on hearing the learned counsel. Your Lordship, see 105.
Yes, 105, yes.
On hearing the learned counsel. On hearing the learned counsel for the party and on perusal of the records placed before me, this court has considered all the aspects of the matter as argued by the parties. On perusal of the records, it appears that the Lotha Baptist Churches Association has already brought out an administrative letter dated 9/2/21, wherein it has been specifically appealed to the applicant that since you have separated and created an independent church from the WTBC, you are not authorized to make use of any land, buildings, property of the WTBC unless the church consents to give you any property from their possession. The administrative order of a religious body should be sparingly be interfered by the court as far as practicable. So this was the decision of this Honorable Court when they filed an application for vacation of the stay. Now, how was the writ petition itself disposed of? The petition was disposed of at page beginning from page 107, Lordship, but we'll go beginning from page 10. Yeah. 107, man. 107. Let me, if you can go straight to page number 1. Page 109. Page 109.
Yes.
When the matter came up, Your Lordship,
Yes.
in the middle of the page, when the matter came up for hearing today, Mr. C.D. Jamil, Learned Senior Counsel, preparing for the respondent, submitted that certain developments has taken place during the pendency of the writ petition, and in view of the same, the writ petition can be disposed of at this stage. Mr. C.D. Jamil submitted that the Lotha Baptist Churches Association, which is the apex body of all the Baptist churches among the Lothas through letter dated 14/8/21, has informed the respondents that the association's executive committee, in its meeting held on 13 and 14 August 2021, has recognized them as independent, full-fledged local church under the Lotha Baptist Churches Association, with all liberty and privileges accorded by the association, and accordingly, the church's recognition certificates has also been issued. In view of the recognition of by the apex body, the respondents who are already having their own church buildings, will start worshiping separately in those buildings. Look at the language here. Look at what was pleaded, my lord. Separate buildings, separate churches will start worshiping separately. Mr. Vikram, Learned Counsel for the petitioner, admitted that the respondents have been recognized as independent full-fledged churches by the LBC, but submitted that though they may be recognized as independent churches, they may still come to the mother church. So this was our apprehension. They are saying that they have separate churches, but they might still come to the mother church. And what is the mother church, Your Lordship? Wokadon Baptist Church, the main church, plus the 3 colony churches. And in that event, there are chances that misunderstandings will once again crop up, which may create law and order situation. To this, Mr. C.D. Jamil, Learned Senior Counsel, submitted that the respondents have their own church buildings and they have no intention to go back to their church for worship. This is the statement, Your Lordship. They have their own church. So why should we object if they say they have their own church? In view of the submission of the learned counsels and the developments that are stated to have been taken place. So these are the developments, Your Lordship, that they have their own church. This court is of the view that no purpose will be served by keeping the writ petition pending. Therefore, it is disposed of with a direction to the Deputy Commissioner Woka to hand over the keys of the churches to the respective functionaries so that the parties, plurals everywhere, Your Lordship, not the party, not the petitioner or the respondent, may be able to worship in their respective church buildings. They have their own church buildings, we have our own church buildings. We may worship in our respective church buildings and start functioning immediately, independently. In view of the disposal of this petition, the interim order passed earlier shall no longer have any force. So, taking advantage of this order, Your Lordship, the petitioners, the 3 so-called independent churches, they took over all our properties. We sought to prevent them, because of which the review application was filed. Now, in the review application, Your Lordship, on the 23rd of page 118. But firstly, Your Lordship, if Your Lordship will come to page 1111. What is the letter of the Lotha Baptist Churches Association, which granted them independent status? 14/10/2021. This is the Lotha version, and the type copy is at page 112. This is addressed to the three churches again. The undersigned is pleased to inform you that the LBCA Executive Committee, in its meeting held on August 14, 2021, has recognized you as full-fledged local church under Lotha Baptist Churches Association with all liberty and privileges accorded by the association. Simply a letter which says that they are recognized as independent churches. Nothing more, nothing less. Then at page 113. No, interim order. The order of status quo is at page 113. Page 113. The Lordship got it? At the time of filing a civil review petition 3 of 2021.
Yes.
And this order is dated 23/9/21. Can you note the date, madam? 23/9/21. And the status quo is mentioned at page 116. Status quo as on date. At the bottom of the last paragraph. 116. Has Your Lordship got it? So status quo as on 23/9/2021. At page 116, the last paragraph.
Till the next.
So by misrepresentations, Your Lordship, by misrepresentations, they took possession of all our three churches, including all the properties attached to these churches. Pastors' building, residences, Sunday school areas, open spaces, everything. Now, very conveniently, the petitioner is saying that when this honorable court says the churches should be, the respective churches should be given the church, it means that they alone should be given the keys of the churches. And it means also that the keys of the churches means the open fields, the buildings, the apartment blocks, the pastors' residences, the Sunday school areas, everything. That's what they're trying to interpret now, Your Lordship. Then how was the review application disposed of, Your Lordship? Your Lordship, since this interim order was obtained on the basis of misrepresentations, I filed an application for recall of the interim order.
This is 23/9/21 is
In the review application, an interim order was passed.
in the review application.
Yes, an interim order was passed.
Till the next date of hearing.
Yes,
Status quo is-
but it was continued, Your Lordship. The date is important, Your Lordship, as on 23/9/2021.
So it was to be with the applicant.
Yes, with them.
Hmm.
On the basis of misrepresentations, they had taken possession of all the properties that belong to us. And status quo order as on 23/9/2021 was ordered. When the writ petition was disposed of, Your Lordship, on, kindly note the date. 16/9/21. Your Lordship, the writ petition from which this review application arises was disposed of on 16/9/21. Your Lordship will find that in page 107.
This writ petition disposed of on
16/9/21. Writ petition number 69 of 21,
page.
page 107. 16/9/21.
And then this is review.
This is review 23/9/21. And the review petition number is 3 of 2021. The interim order is at page 113. Page 113. Is the lordship got that?
Hmm.
113.
The review was filed by them.
Yes, my lord.
So
And the
inter-
interim order was 23/9/21.
interim in their favor.
Yes, 23/9/21.
Hmm.
So I filed an IA for recall of this interim order.
Hmm.
IA was disposed of together with the civil review petition, and the order of disposing of the civil review petition is at page 118. Has your lordship got that?
Yes.
Page 118. And the judgment in the review petition is dated 24/2/23. 24/2/23. Relevant portion, can we go to the relevant portion? Your lordship?
Hmm.
At page 141. Beginning from, we can start from page 140, the last paragraph. As stated above, paragraph 11, your lordship. As stated above, in any case.
141.
Page 140, my lord. 140, paragraph 11, at the bottom of the page.
Okay.
Page 140.
Okay. Yes, yes.
As stated above, in any case, this court is not the right forum to decide regarding the rights and titles of the parties over the properties at this stage. So the first finding is that you have to file a civil suit. Regardless of anything else, all the proceedings, as far as disputes to immovable properties are concerned, this is not the right forum. They must first be decided by the civil court, having geographical and pecuniary jurisdiction as already stated. If the prayer of the petitioners in the review petition is considered and allowed, it would amount to stepping into the shoes of a civil court. It would also amount to doing something indirectly which cannot be done directly. As such, precisely stating the parties will have to approach a civil court of competence having jurisdiction to decide the dispute over the properties. Accordingly, the review petition and IA are disposed of with a direction that a party should maintain status quo regarding the properties as the day of the order dated 16/9/21. This date is important, Your Honor. Not the date of the status quo order in the review petition. The disposal of the writ petition itself, 16/9/21, where this honorable court directed that the parties, not the parties on both sides be given the keys to their respective churches. This is a very telling fact, my lord. This is a very telling fact as far as the decision of this honorable court is concerned. And not only that, lordship, at page 140, why this decision came about, there is a pointer to that at page 140 in the paragraph which starts from before the order. Before the order sought to be reviewed and was passed, Mr. City Jamie Learned Counsel for review petition is submitted only that the writ petition can be disposed of since the respondents who are review petitioners have been issued certificate of full-fledged independent church. And since they have their own church buildings, they will continue their worship in those buildings. As such, no more problems will arise between the parties. This was the submission, my lord. The Learned Counsel for the writ petitioners, Mr. Wickham, who was also present, did not deny or counter the claim of the respondents that the three sector churches have been recognized as independent churches. So why should we object, Your Lordship? If they say they are independent churches, they are independent churches. The only concern expressed by him was that even though the respondents are recognized as independent churches, they may still come to the church for the petitioners for worship, and if that happens, problem may arise again. This is a very genuine concern, my lord. However, again, this is important, my lord. However, the fact that there are other properties for which no decision has been taken by the churches was not brought to the notice of this court. So by relying on the decision of this Honorable Court in the judgment and order dated 16/9/2021, the petitioners have taken over all our properties. All our properties. And the fact that they say that they have their own churches is a lie, a blatant falsehood. A blatant falsehood, Your Lordship. They have not hesitated to lie before this Honorable Court. They have the three petitioners in the three revision petitions before this Honorable Court. They have held themselves out to be persons representing the three churches. Their representative capacity has been accepted by this Honorable Court. Their appearance before this Honorable Court has been in a representative capacity, has been accepted on their holding out their competence to represent the three churches in their representative capacity. Decisions have been rendered by this Honorable Court. Now, just to frustrate the case of the plaintiffs, the respondents in this case, just to frustrate the case of the plaintiffs, they are filing applications after applications. First, they filed for rejection of plaint. It was rejected. Now they are saying that they are not competent. Firstly, they are saying, Your Lordship may kindly note this. Firstly, they are saying they represented in a representative capacity. Now they are saying they do not have the authority to represent in a representative capacity. But the fact of the matter is, once they have represented in a representative capacity, can they resign? Can they resign from that position? And when a suit is filed in a representative capacity, it binds each and every member of that organization. Each and every member. Each and every member. On this point, Your Lordship.
Now, what is the status quo? The key is with whom?
All with them. Everything with them.
So they are functioning.
Yes. All properties are with them.
Hmm.
On the basis of falsehoods and misrepresentations, by misleading the Honorable Court, everything is with them. Everything is with them. Now, 2017, Lordship, the authority which I wish to place before your Lordship,
Yes.
on the point of representative capacity
Hmm.
and the law relating to representative capacity.
Hmm.
Once a party holds himself out to be representing a particular organization in a representative capacity, can you resign from that fact? No. Once orders have been passed in a representative capacity, it binds every member of that organization. 2017, Your Lordship, 15 SEC.
Yes. Hello, sir.
2017, 15 SEC, 333. Now, Your Lordship is aware, most of the authorities in respect of religious and spiritual matters arise in South India. This is also one such case, Your Lordship, and this is in relation to the Syrian Orthodox Church. In this case, Your Lordship, many issues were discussed, but going straight to the issue of representative capacity, if you might take Your Lordship to paragraph 77 at page 429. At page 429.
Para 77.
Paragraph 77. I'll start from that, Your Lordship.
Hmm.
This court has clearly held that the patriarch could not have unilaterally appointed priests through his delegate. It is one thing to say that a patriarch could do this thing in cooperation with the Catholic cause, but the ordaining of the priests and metropolitans by him and his delegate without reference to and over the protestations of the Catholic cause was certainly not the right thing to do, since it purported to create a parallel administration mechanism from the church in spiritual temporal matters. So again, Your Lordship, a parallel administrative system within the church. So in the three colony churches, what is happening is a parallel system of administration is trying to be put in place by the petitioners. And if Your Lordship will see the array of parties, the parties to the case also, it is K.S. Verghese versus St. Peter's Syllabus Orthodox Church and others. So this is also something which has been filed in the representative capacity. 78. The aforesaid findings and the declaration in the aforesaid decree that was passed in the 1995 judgment extracted above in a representative suit is binding. Now, why? Here, Your Lordship, if you may pause for a moment. If you may pause for a moment. Usually in suits, what happens is that suits are filed in a representative capacity and it goes up. It goes up through the procedure prescribed by law. Appeal to the Honorable High Court, to the Honorable. For us, the representative capacity started in the High Court and it percolated down. the representative capacity was already accepted by both parties. That's the difference, Your Lordship. Now, is binding. This court in such and such has dealt with the suit under section 92 and order 188, and it was held that such a suit is the representative action of a large number of persons who have a common interest. The suit binds not only the parties named in the suit, but all those who are interested in the trust. So the point is, Your Lordship, all of us are interested in the properties of the Gauhati Baptist Church. And once an order is passed in a representative capacity, it binds everyone. Binds everyone. It is for that reason, explanation to 6 to section 11 CPC constructively bars by res judicata the entire body of interested persons from re-agitating the matters directly in issue in an earlier suit under the section 92 CPC. This court has laid down thus. So therefore, Your Lordship, the argument was raised that those persons who represented the trust were representatives by name, and these persons were actually not parties to the suit. The Supreme Court said, no. If you file in a representative capacity, it binds every member. It is not necessary to go into the finding of the High Court that two of the appellants, being Muslims, can have no interest in the trust, as the other two appellants claim to be the beneficiary of the trust, and their claim has not been negative. Moreover, the trust has been constituted to perform not only charities of a religious nature, but also charities of a secular nature, such as providing for drinking water and food for the general public without reference to caste or religion, etc. Section 11 is all about res judicata. No need to go into that, Your Lordship. Then, no need to go into all that, Your Lordship. Then paragraph 80. Lordship, paragraph 80. The submission, the declaration under section 35 of the Specific Relief Act is in personam in the 1995 judgment, has to be considered in that spirit, cannot be accepted in view of the aforesaid discussion. So only parties, the ground that was taken here, Your Lordship, is only the judgment is binding on only the parties who are named, not anyone else. But the Honorable Supreme Court said, no, if it is in a representative capacity, it binds everyone. And therefore, a subsequent suit is barred by section 11, the principles of res judicata. Then, Your Lordship, paragraph 80. Moreover, in the suit culminating into the 1995 judgment, the relief was not sought inter partes. It was not in personam. The relief that was sought were common to the Malankara Church. Thus, the provisions of section 35 cannot come to the rescue of the appellants as to prevent the bar of res judicata. Section 35 is about the declaration of decrees in civil suits binding the parties concerned. The court in Razia Begum has also observed that section 43 of the Old Specific Relief Act, which is corresponding to section 35 of the Act of 1963, is not exactly of res judicata. It was open to the appellants to become a party in that earlier representative suit to defend the common rights which were agitated. Thus, they cannot escape the rigor of the aforesaid provisions and res judicata. 82. It was submitted that disputes as to faith and worship in the church have to be decided in their presence so as to bind the parishioners. In our opinion, the parishioners were parties in the previous suit decided in 1958 and 1995 and earlier thereto. So all the members of the congregation are parties to the proceedings thus far, Your Lordship. The question cannot be reopened again and again by them on the ground that they were not parties individually. Otherwise, the representative suit and issues as well as the right of suing in representative capacity would lose entire significance. This is the point, Your Lordship. Every now, time and again, you resile from your earlier stand and say, I'm not a representative anymore. Is it possible? Is it permissible? No. The Honorable Supreme Court says no. If that is the case, the very idea of filing a representative suit in a representative capacity loses significance. It becomes useless. No doubt it is true, it is held that the true beneficiaries of religious endowments are not the idols but the worshippers. Therefore, Your Lordship, representative capacity, the temple cannot be a party, the church cannot be a party, it has to be in a representative capacity. This principle has also been reiterated in such and such. There is no dispute with the proposition that the persons who go in only for the purpose of devotion have a greater and deeper interest in temples than mere servants who serve there for some pecuniary advantage. The decisions are based on Hindu religion. However, the principle is one of law applicable to all religious institutions, including the churches having a public character. So these principles apply to all denominations, all religions. Now, then again, Your Lordship, apart from the issue of this representative capacity and the fact that the petitioners cannot say now that they cannot be dragged into this suit anymore, that is beyond argument now, Your Lordship. They have held themselves to be filing, defending in a representative capacity. They cannot resile from that now. That is the law laid down by the Honorable Supreme Court. And not only them, it binds everyone. Everyone. It binds me, the entire member of my congregation. It binds them, the entire group who claim to be a separate church. Now, the conclusions. This is not with regard to representative capacity, representation, Your Lordship. But this is about what if someone claims to have formed a different faction? What right does he have? Your Lordship will find in paragraph 228 the conclusions, and they make for very interesting reading, Your Lordship. At page 512. This is apart from representative capacity. 228 at page 512.
Yeah.
May I read, my lord?
Yes.
Resultantly, based on the aforesaid findings in the judgment, our main conclusions inter alia are as follows. 1. Malankara Church is episcopal in character to the extent it is also declared in the 1934 Constitution. The 1934 Constitution fully governs the affairs of the parish churches and shall prevail. Now, what is the 1934 Constitution? Your Lordship, the Malankara Church had a written constitution. The Wokathon Baptist Church also has something of a similar nature. And unless the Wokathon Baptist Church consents to give away the properties to the so-called independent churches, we cannot be compelled. All that will be decided in the civil suit, Your Lordship. All that will be decided in the civil suit. Then, 28.2. The decree in the 1985 judgment is completely in tune with the judgment. There is no conflict between the judgment and the decree. The 1985 judgment arising out of the representative suit is binding and operates as res judicata with respect to the matters it has decided in the wake of the provisions of Order 1, Rule 8 and Expression 6 to Section 11 CPC. So, Your Lordship, the decisions in the writ proceedings, in the review application, where we have been taken to be filing on behalf of the Wokathon Baptist Church in a representative capacity, where they have been held to be representing the so-called three independent churches in a representative capacity. It is binding. They cannot resile from that ground anymore. Then, 228.4, as the 1934 Constitution is valid and binding upon the parish churches, it is not open to any individual church to decide to have the new constitution like that of 2002 in the so-called exercise of right under Article 25 and 26 of the Constitution of India. It is also not permissible to create a parallel system of management in the churches under the guise of separated spiritual supremacy of the patriarch. We have something similar here, Your Lordship. This group claims to be a different church now, but can they do so without the consent of the Wokathon Baptist Church? No, they cannot do so. Then 228.5. The primate of the Orthodox Syrian Church of the East is Catholicos. He enjoys spiritual powers as well as the Malankara Metropolitan. Malankara Metropolitan has the prime jurisdiction regarding temporal, ecclesiastical, and spiritual administration of the Malankara Church, subject to riders provided in the 1934 Constitution. The Constitution which governs the church, that is the guiding principle. Full effect has to be given to the finding that the spiritual power of the patriarch has reached to a vanishing point. Consequently, he cannot interfere in the governance of parish churches by appointing new vicars, priests, deacons, prelates, etc., and thereby cannot create a parallel system of administration. The appointment has to be made as per the conferred under the as per the power conferred under the 1934 Constitution on the diocese, metropolitan, etc. concerned. All functions have to be taken in terms of the Constitution of the Syrian Church. No one can do so of his own volition. No one can do so kushi, as we like to say in this part of the country, Your Lordship. 228.7, though it is open to individual members to leave a church in exercise of the right not to be a member of any association, and as per Article 20 of the Universal Declaration of Human Rights, the parish assembly of the church, by a majority or otherwise, cannot decide to move church out of the Malankara Church. Once a trust is always a trust. This is the point, Your Lordship. It is my church. Unless I allow them to separate, they cannot claim to be separate. to the next paragraph, Your Lordship. When the church has been created and is for the benefit of the beneficiaries, this includes everyone. It is not open for the beneficiaries, even by a majority, to usurp its property or management. The Malankar Church is in the form of a trust in which its properties are vested. As per the 1934 Constitution, the parishioners, though may individually leave the church, they are not permitted to take the movable or immovable assets, properties out of the ambit of the 1934 Constitution without the approval of the church hierarchy. This is where I will stop, Your Lordship. Of course, there are other findings also, but this is where I will stop. Without the approval of the Walkertown Baptist Church, the mother church, the parent church, they cannot separate. But these are issues which should be taken up in the civil suit, Your Lordship. These are issues which should be taken up. The only question is, having represented that they are representing the three churches in a representative capacity, that plea having been accepted by the Honorable Court in the writ proceeding, in the review proceeding, can they resile from that stand and say that they do not represent the three churches in a representative capacity anymore? That is not permissible. That plea, if it were allowed, Your Lordship, it would mean that the provision for filing in a representative capacity loses its significance. And that is not permissible, as the Honorable Supreme Court says in this judgment. So that is my case, Your Lordship. And the only point of concern which I would like to point out again, Your Lordship, is the civil suit was filed in April 23, in the month of April 23. On some ground or the other, the matter has been adjourned, the suit has not been progressed. So my humble plea, my humble prayer, Your Lordship, is that this application is false, is vexatious, and it needs to be strictly dealt with, needs to be dismissed with exemplary costs. And because of the stay which is in operation, Your Lordship, the newly impleaded defendants, I have not been able to take any step against them also. That is my case.
There is a stay.
Yes, my lord.
So what if the church is impleaded and then represented by this
Yes.
person?
Yes.
The church, supposing.
The only thing, my lord, is this is pure mischief, nothing more. Pure mischief. Look at the language of my plaint, Your Lordship. It is Mr. So-and-so representing the Samian Baptist Church. It is not in his individual capacity. It is in a representative capacity. So what difference does it make whether I say Samian Church represented by Mr. So-and-so?
Yes. What is the difference?
There's no
Seven
difference.
church represented by so-and-so and then Mr. So-and-so
Yes.
representing the church. What
There's
is
no difference, my lord. It is just semantics, different construction of sentence. What is the difference if I say the state of Nagaland represented by the chief secretary, or the chief secretary representing the state of Nagaland? But in this case, Your Lordship, in the review application, they have made categorical statements. They are all responsible. They are responsible for these three churches. They are the convener, the secretary of the three churches, the action committee. Their own statement. They are not just mere members. And their plea to file the review application in a representative capacity was accepted. It was accepted, Your Lordship. It was not as if some dispute arose and that their claim of filing the review application in a representative capacity was dismissed. No, it was heard. The review application was heard. They were permitted to file in a representative capacity. We were permitted to file in a representative capacity when we filed the writ petition. As I was drawing Your Lordship's attention, is Walkertown Baptist Church represented by its so-and-so.
Yes, that is what he wanted. Church represented by.
Just language, Your Lordship. But he's going beyond that. He's saying he doesn't have the authority to represent anymore. That is where he's wrong.
That cannot.
Yes, that is wrong. That is wrong.
He has already
Yes.
represented and the
Yes.
dispose of.
Yes. If he wants me to change the language and say Samian Baptist Church represented by him, I'll change that. That's not a problem.
Okay.
But he is saying he cannot be a party. He doesn't have the authority anymore. That is what he is saying. Would that be permissible? That is the point, Your Lordship. So that is my case, man.
Okay. Anything else?
Yes.
That's enough. Okay.
We are going little beyond the proportion, the issue involved in the case. That's why it has compelled me to clarify certain facts.
Yes.
As if we are deciding the civil suit,
Yes.
who is the owner of the property. That issue will be decided in the suit.
That will be decided.
To
in the suit.
decide that, who are the proper parties to show us to decide the title.
That is the issue. So we are to decide, this honorable court has to decide on that issue only. But the submission went further that who is the owner. So to clarify that, initially I was also making a submission in the background that initially it was only one church we started together. It was developed by all. No individual has an individual ownership over the church. All property, everything belongs to the church, and we were all one. My learned friend has tried to project the facts in such a way that we are different entities. We were same, one. Town was developed, but in due course it was expanded. For example, shortest example I will cite Au Baptist Church, Dimapur. In short, it is called Daba Dimapur Au Baptist Church. Dimapur is such a big city. Now, initially they started with a small church. That was in 70s only, late 60s. And then slowly and slowly the town has been developed. So many fellowships happen for under the umbrella of the main church. But it has become difficult to administer and monitor all the churches through one mother church. Therefore, independent churches were given, and at present, there are so many independent churches who were initially under the umbrella of Baptist Church. Our Baptist Church, main church, was also developed by all. When it was granted independent, there was no dispute whatsoever. Since the fellowship property was developed by all, main church was also developed by all the believers. Therefore, there was no issue allocating, granting independent church. They are functioning as independent. Like that, in a similar way, in Okatown Baptist Church also it happened. That is the reason why I would like to refer to page 78 of the petition. This is the petition taken by all the members, all the believers of the Okatown Baptist Church, including the believers who are the members in the 3 independent churches now. It's not that they belong to different entities. They belong to one entity only. But in due course, independence is accorded. And for that, general decision was taken by all the members. This is a decision dated 28 March 2017. WTBC means Okatown Baptist Church General Meeting. It includes all the members of the main church and the 3 independent church members. Can you see? Let me read the English version.
Page 78.
7-8.
Okay.
Translated portion is in the bottom, Lordship.
Yes.
NST Sharon sector, that is defendant number 3. NST Sharon sector, 2 sectors have written to the Deacon Port for giving them independent church after 100 years jubilee. On this matter, the Deacon Port has brought out the agenda. It is decided that it shall be released under the guidance and supervision of the Deacon Port after the jubilee. This is not a decision of only the Okatown Baptist Church. This is a decision of all the believers, including 3 churches, which goes to show that all of us are one. And decision was taken in 2017. Next page, 79. This is decision dated 25/11/2017, Okatown Baptist Church General Meeting. To release 2 sector churches as independent, it has been reaffirmed as per the meeting minutes so-and-so 25/3/2017 that it shall be released under the guidance and supervision of Deacon Port after 100 years jubilee. Reaffirmation. Again,
This is in respect of 2 churches.
2 churches.
Out of this-
Initially, there was only 2.
Out of these 3. Okay.
Yes, initially there was only 2. And then can we come to page 80? This is a decision of 1st September 2018. The Okatown Baptist Church convened a general meeting. Members present 495. It includes all members of the main mother MTBC,
and the members of the three independent churches. As per the general meeting resolution dated 25/3/2017, resolution number 6 of 2017, Bongocho Sector Church, that is defendant number 1, will also be given independent church as per their willingness. Therefore, along with Sharon Sector Church and NST Sector Church, the Deacon Port shall work out all modalities and release them after 100 years jubilee. But since these resolutions and decisions were not implemented, the members of the three churches approached the Ukadon Baptist Church. Look, we have already taken a decision.
This all will be decided in the main suit.
Yes.
Yes.
What, this one?
Yes.
This is,
Please.
I'm referring to the decision taken
Yes.
for granting independent church,
Yes.
for granting independent church.
Mm.
Now, the projection was made that as if they are the only members of the entire church. The present three independent churches were developed by all of us
Yes.
as the brotherhood of the church. So the only issue is whether to grant independent or not. That was the issue pending.
Right.
And that was decided in the month of August, granting independent by the Luther Baptist Churches Association. That is how we were become independent. Second point, on the representative capacity. My learned friend has referred to the filing of the present suit. Undue authorization, this has been filed. I have also represented in the review petition and in the earlier proceedings undue authorization by the church in the representative capacity. But the moment when that proceeding is over, everything comes to an end. It is not automatic that if I represent in one proceeding, that will qualify me to participate as an authorized person in another proceeding. No.
It was not,
Because-
not authorized to represent all connected with the churches.
Yes.
It was, but authorized.
For a particular proceeding. Number one, the basic distinction and confusion why they are still coming up with this confusion is, I'm as an individual, I am not the church. Church is not me. Church is one organization body. I'm one individual. If the church takes a decision, then authorize me. I can represent the church. Therefore, once I'm appointed to represent in one particular proceeding, that will not automatically qualify me to represent in another case. For example, a situation may arise that I have been authorized to represent in one of the cases. In another proceeding, parties were same, but I have not been authorized. But it so happened that I just went taking the plea that, look, since I have been authorized to participate in the High Court, I also have the authority to represent even in this proceeding. In the subsequent proceeding, I have not been authorized, but I participated and an order was obtained where I have been granted the compensation of 5 crores. For example, now, church may come and say, you are not authorized. Who has authorized you? I have authorized you only to represent in the High Court, not in the lower court. Without making the distinction of this difference, they are coming with the representative capacity. That's how the learned court below has gone wrong. That, look, since in the review application, you were authorized by the church to represent the church in the High Court, even here also, without authorization by the High Court, you can represent the church. You come and then represent. Church should be made a party. And when the Lordship has put a query to my learned friend, what is the difficulty? There is no difficulty, no difference. If there is no difference, what is the difficulty to make the church as a party? If I'm authorized, then I can represent. Let the suit be proceeded with proper party. Without authorization, how I can represent the church? That is my case.
Church may also say that no, he is not authorized this, some other person has
Yes.
been authorized this time.
Yes, church may say that. Church may say now, even now, if I go and represent, we have not authorized you, on what authority you are representing the church? But you have forcefully made the party. So far, the church has not been made party. So can I be the owner of the property just because I have been made to represent the church by the plaintiff? Can I be the owner of the property? No, I cannot be. I cannot speak on behalf of the church unless I'm authorized. But they have forcefully take me to the case and then made me party. You should represent the church. That is wrong. It is not the plaintiff who should decide who should represent the church. The court, learned court below cannot also decide who should represent the church. It is the church, independent churches, who should select a person and authorize and represent them. That is the normal way of doing the things. So what prevents them to make the church as party, as the churches were the parties in the review proceeding? And this honorable court said that the parties, who are the parties in the review? Because civil suit is filed in terms of the order passed in the review application. They were allowed, parties were allowed to file suit.
But in the review also, the parties means the parties in your church is being represented by the present person.
I have represented in the High Court, let the plaintiff make the church as a
So
party.
you mean to say the authorization was limited to for that only?
Yes,
So,
yes,
Your Lordship.
because it is
It-
not
it-
mentioned.
There is again a misrepresentation which is being made.
No,
If your Lordship will come to page 164,
Hmm.
page 163, page 163. This is a blatant misrepresentation. This kind of misrepresentation should not be allowed.
kindly come to
Page 163.
page 50.
just a minute.
Page
One,
163. Page 163.
163.
Yes, ma'am. So this is what they stated in the review application, Your Lordship.
Yes, Your
No need to repeat that again.
Hmm.
At the last sentence at the bottom.
Hmm.
All the applicants were authorized by 3 churches to file an instant review application and to take any steps
Any steps?
for redressal of the grievances of the 3 churches on their behalf. That is one.
That is my
Yes.
query was.
And then there is one more
So
thing,
it
Your
was
Lordship.
only limited for that or not?
No, and there is one more thing, Your Lordship.
Hmm.
One more very vital factor which the petitioner is not acknowledging. We are the mother church. We are saying we do not recognize the 3 independent churches. We do not recognize the 3 independent churches. These are the 3 persons who are heading the so-called 3 independent churches. They are members of the action committee.
My lord, I'm
There is a
replying.
difference here, Your
I'm
Lordship.
replying to his submission.
There is a difference here, Your Lordship.
Just, okay, let him come. Okay. So what do you say about this? 163?
163, kindly come to last 2 sentences, last 2 lines.
Yes.
All the applicants,
Hmm.
that's your lordship, but 163.
Yes.
All the applicants were authorized by the 3 churches to file the instant review application.
And
The instant review application
uh,
and to take steps for redressal of the grievances of the 3 churches on their behalf. That is in the instant review application, not in all. That is why I'm saying it is not automatic that once I'm authorized to represent in one particular proceeding, that do not automatically qualify me to represent in other proceedings as well. It is not automatic. That is what I'm submitting, Lordship. They are trying to twist the matter in such a way that since you are authorized to participate in all the cases, that is not correct. Now, kindly come. What they are saying, I'm supporting their stand. So, page 50. Representative capacity. How it should be represented. This is an affidavit by the plaintiff number 2. Paragraph 1. Has your lordship got it? Page 50. Paragraph 1. Has your lordship got it?
just Yes.
This is the affidavit by plaintiff number 2.
Hmm.
That I'm one of the plaintiffs in the accompanying suit. I am fully conversant with the facts and circumstances of the case and competent to swear this affidavit for myself and on due authorization for and on behalf of my co-plaintiff. Co-plaintiff is Okatown Baptist Church, that is plaintiff number 1. It has to be authorized in this manner. This is what we want. He has shown the affidavit on behalf of the plaintiff number 1 on due authorization. Kindly come to page 108 again. This is the order which my learned friend has referred to.
This is affidavit in.
No. This is the order passed in the writ petition, Lordship. 108. My learned friend has referred to. My submissions have been read out. Let me not repeat. 109. Last 2 paragraphs. My submissions are there in the bottom. The last bottom one is the counsel for the present plaintiff, Lordship. Last paragraph, may I read, Lordship?
Yes.
Mr. N.K. Loikam, learned counsel for the petitioners, that is the plaintiff now, admitted that the respondents have been recognized as independent, full-fledged churches by the Lota Baptist Churches Association, but submitted that though they may be recognized as independent churches, they might still come to the mother church for worship, and in that event, there are chances that misunderstanding may once again crop up, which may create law and order situation. To this, Mr. C.D. Jamir, learned senior counsel, submitted that the respondents have their own church buildings and they have no intention to go back to the mother church for worship. Now here, the word independent. What is meant by independent? Independent means full-fledged independent. If it is not granted full-fledged independent, then on what basis I can also claim? What is meant by independent? On one hand, independent has been granted. On the other hand, they are saying that, no, we are one. It is not so.
This is another misrepresentation. All these issues will be taken care of in the civil suit. Yeah. Can my learned friend say that these 3 properties are in the name of the 3 churches?
And Lordship, what
No.
I'm going to show is
Today,
this
all
order.
3 churches are in my name.
Whatever may be the order, this order has been accepted by the writ
No.
petitioner. They have not challenged this order. If
Because
there is any
they
reason
have their own
in this
churches.
order, they could have challenged.
Your Lordship, may I ask my learned friend, Samayan Church, in whose name is it?
Now,
The other 2 churches, in whose name is it? The
my
property?
learned friend has referred to the dismissal of the application filed under Order 7, Roll 11. This has been already decided. My submission on this point is very simple. And only one answer is dismissal of an application filed under Order 7, Roll 11. Do not debar me to file an application under Order 1, Roll 10, Clause 2. And if so, if they are saying, and if anybody is saying that no, once the application filed under Order 7, Rule 11, you cannot file any other application. Can that be the law? If that is the law, at least educate me. Dismissal of the application filed under Order 7, Rule 11, do not debar me to file an application under Order 1, Rule 10, Clause 2.
Again, Your Lordship, in the application on Order 7, Rule
Rejection
11,
of the plain
the ground taken
is
that
one thing.
he is not a necessary party. In the application on
Rejection of the plain is one
striking
thing,
of his name, same thing. Same
and
thing.
deletion of name is another thing. This cannot be mixed up. Rejection of the plain application and deletion of names are 2 different things. And I have filed an application under Order 1, Rule 10 for deletion of my name only. Just delete me. Because it is not automatic representation. Just because I have been authorized to represent in the review petition in the High Court, that do not automatically qualify me to represent in another different proceeding in the lower court. And as I have been repeatedly submitting, Lordship, the order which has been passed in the writ petition on 16/9/2021, they have not challenged this order. They have accepted no review, no writ appeal.
Should that order merges in the order by which a review was disposed of? Oh, that's again another fundamental principle of law.
And my learned friend has referred to the interim order passed in the review. That is the order dated 23/9/2021 at page 113. Now, this interim order has been merged with a final order on 24/2/2023. The order dated interim order dated 23/9/2021 passed in review application has been merged with a final order dated 24/2/2023. Therefore, no benefit on the basis of the interim order can be derived from this order. No party can derive any order because interim order has been merged with a final order of 24/2/2023. Now,
So,
to
just-
conclude,
just-
Lordship.
Yes.
Yes, Lordship, want
Yes,
to
please
put
conclude,
some
sir.
question. Just to conclude, my learned friend has made a submission that to frustrate the plaintiff, the defendants are filing application after application. That is what the submission was advanced by my learned friend. My only reply in this point is, if you want to file a suit, you file the suit in a proper manner, in proper form, in accordance with law. And if the suit is filed in a defective manner, nothing bars me to file application after application. But so long as it is filed in accordance with law, even if I raise objection, this honorable court will definitely reject, or for that matter, any other court will reject. But what application I have filed to proceed the suit in accordance with law in a proper manner, in a proper procedure. That is how I have filed an application under Order 1, Rule 10, Clause 2 for deletion of my name. Because the party, in terms of the order passed by the honorable court, the parties were allowed to file a suit in appropriate forum. Now, the parties in the review petition was the churches. So churches should be made party. Nothing debars them to make the church as party. Since they have committed a mistake, they want to defend that mistake again and again, that it is proper. No. The parties in the High Court were the three churches. So let the three churches be made party and my name may be deleted. And whoever is authorized by the church, they can represent the church. That is the proper
So
procedure.
you have no problem if the respondent implead
The three
respondent or
churches.
the plaintiff implead the church represented by
No.
in a part.
They cannot propose that. They let them make the church as party. Church will decide. It is not they who should decide my fate. It is me who should decide my fate.
No, as we have seen the Supreme Court decision that since you have already represented, you
That is in
cannot-
representative
Right.
capacity, Lordship. Let us be very clear on this. Representative capacity.
Yes,
That's the point.
Representative capacity.
yes.
Unless I'm authorized, I cannot represent. Representative capacity, that's how they went wrong. Representative capacity. I have just referred to page 50, where the plaintiff number 2 has made a statement in the affidavit that I have been authorized by plaintiff number 1 to swear this affidavit. Authorization has to be there. Without authorization, how can I represent? My representation in the review was undue authorization. It is, I have clearly shown in this review application, not automatic, not in other proceedings. So let the church be made party. Let the church decide who should represent the church. They will come. How my church should be decided by them? Who should
Your
represent?
Lordship, I think this argument has gone on long enough.
Right.
Church is not a juristic entity. That is settled law.
So
It
that
has
is
to
why,
be
that
filed
is
in the
why,
representative capacity.
somebody has to represent the
Yes.
church. Because you have already represented the church in the
Yes.
High Court, in the review petition also. You have been authorized and to do anything with regards to the church.
Kindly come to again page 118. Who were the parties in the case?
Yes.
And this honorable court said that the parties were directed, allowed to file suit. 118. Who were the parties? Three churches were the parties in the review. So what prevented them to make three churches as party in the
Now,
suit?
now supposing the church is made as a party
Yes,
represented by
Lordship.
you, and then you can make a prayer filing an application that no, he is not the representative now. There's some other person. This is the person who is now will now represent the church.
It is the bureaucrat of the church, but Lordship,
Hmm.
I'm submitting repeatedly.
Hmm.
Let them implement the church as party.
Now they
One.
now in that case they will implead the church represented by the new person.
No. See the cost title.
Hmm.
See the suit.
The cause title is defective, Your Lordship. My learned friend doesn't seem to understand that. The cause
See the
title is
cause title.
defective.
In the review.
Yes, the defective cause title
Yes.
cannot be the basis of his
So
claim.
this should
Number
have been,
one.
of course, should have been represented.
Yes. Cause title-
Church should have come first.
And he's trying
And-
to impose his defect upon his honorable court.
They have already taken a decision before the proceedings. The plaintiff has already nominated this person, the petitioner, to represent the church. They are strangers.
Okay.
Shamayan Baptist Ekamko
Hmm.
can take a decision who should represent them. Let them decide. But first, they should be made as party, as was made in the High Court. Because in the High Court, in the review application, the parties were three churches. And thereafter, subsequently, they have taken a decision to authorize the present petitioner to represent the church in the review petition, not in other proceedings. And kindly come to 108. This is the petition filed by them, huh? Writ petition filed by the writ petitioners, the present plaintiff. This is the writ petition.
Hmm.
First page 107, Lordship will find the
Yes.
petitioners, respondents, 108, page 108, 3, 4, 5. Here also, had he given any individual person to represent the church?
No, I admit, my lord, even my
Record.
petition was defective.
This is what I'm submitting again and again.
But defects should not be basis of any claim in law, Your Lordship. I admit it was a defect in my claim.
If there is defect, then rectify it. That is what I'm doing.
My learned friend wants the defect.
That is
to
what
become
I'm
law.
saying. This is the party in the writ petition. In the review also, same thing.
They themselves appeared, Your Lordship. They themselves appeared.
On your authorization?
Yes.
Yes. Once I'm authorized, definitely I represent. But without authorization, if I come, this honorable court will not accept. Nobody will accept without any authorization. It is their doing, not my doing. It is their petition, not my petition. And they have made three churches as party in the writ petition as well as in the review petition. That is how this honorable court has passed an order, allowing the parties to file the suit. What prevented them to make the church as party? The possible reason would be that since they have committed a mistake already and you don't want to rectify it, and then they want to defend that. That can be the possible reasoning. Otherwise, it is their doing.
they have made the churches as party. Like this, we are insisting that let in the suit also, let the party be like this. So that churches will decide who should represent the church. Okay. I conclude.
Much obliged.
Mr. Siti Jamil, non senior counsel, assisted by Mr.
I am chair.
Non counsel for the petition. I've also heard Mr. Jimomi, non counsel, for appearing on behalf of the respondent. Hearing concluded. I'll keep it, Rajab.
Yes, my lord.
Okay.
All the three petitions the same.
Yes.
Yes. Much
Order,
obliged.
Rajab.
Much obliged.
For admission, item number 10.
Oops. Two. Okay.
May I please, Your Lordship? Am I hearing, Lordship?
Yes. Item? Yes, please.
Yes, Lordship. I have appeared before the IO and my statements are recorded, Lordship.
So he
And
appeared.
yes, as per the order dated 17/9/2024. Hello.
I've received the latest
Okay, so
report status.
My humble submission that, Lordship, it will be made absolute.
what is anything? He was arrested.
No. He appeared before the IO and his statement was reported. So if
Recorded and I have released.
John arrested.
Your Lordship, strong arrested and loose.
John arrested.
Yes, Your
Yes.
Lordship.
Okay.
Statements has been recorded, Lordship.
316. That means he is cooperating.
It's cooperating.
Yes,
Your
sir.
Lordship. He has taken it, undertaken.
Undertaken also.
Yes.
Whether the where it is stated that he appeared and he's.
Your Lordship, yes, the relevant page I flagged it. Page 10 and 11. Page 10 and 11 is the statement of the accused.
So says that arrest procedure has been initiated.
Yes,
Means
yes.
arrested. Okay.
Yes, I have been medical test also.
Now with certain condition, what more condition do you want to put against here?
Your Lordship, this AB can be made absolute. Your
Yes,
Lordship.
that is why. Any other condition
Your
you want?
Lordship.
It's fine only, I think.
Yes, Your Lordship.
Okay. Okay. Mr.
G. Gunamani Sharma.
Okay.
Gunamani Sharma.
Gunamani Sharma. Gunamani, huh? Sharma, SARME. Learned counsel for the petitioner. I've also heard Ms. Esmail, learned PP for the state of Mangal staff. By an order dated 12/9/2024, while calling for the scanned copy of CD from the accused applicant was granted interim anticipatory bail with certain conditions. And on and on 17/9/2024, it was submitted that the accused applicant is ready to cooperate and appear before the eye of the case. Yeah, eye of the case. Accordingly, the accused was directed to appear before the eye of the case within 15 days. From the date of the said order starts. In compliance of the said direction from the accused, it appeared before the eye of the case on 17/10/2024.
17.
7/10.
Sorry, 17.
Yes.
17/2024. Stop. On his such appearance, the accused was arrested in connection with the above case. And after completion of all procedure, after recording this statement under section 161 CRPC, and on completion of all the procedure, accused was released on bail on execution of bail bond. Start. In a bail bond on the same day, On the same day. The learned counsel for the petitioner submits that since the accused has already been arrested and released on bail, and as he is cooperating with the eye of the case, the interim anticipatory bail granted to the accused on 12/9/2024, which was extended on 17/9/2024, may be made absolute, may be regularized and made absolute. Ms. Mere Lana BP, who produced the scanned copy of the case study, was also submitted that the accused has been arrested and released on bail, and now he is cooperating with the eye of the case for investigation. that in view of the above, and since the accused has already been arrested and released on bail, this bail application has become infructuous. Accordingly, the interim anticipatory bail granted to the accused on 12/9/2024, which was extended on 17/9/2024, is hereby hereby regularized and made absolute with the same terms and conditions. Stop. This bail order, this order may be read along with the bail order dated 12/9/2024 and 17/9/2024. So with the above, this bail application stands disposed.
Much obliged.
Yes.
Please, Your Lordship.
Yes.
Along with the main revision petition, I have also filed an IA for which a condonation of delay, for condonation of delay. There's a delay of 63 days.
You have any objection?
Yes, Your Lordship. Lordship,
Delay can be condoned?
Lordship, if I may be allowed to give a brief submission.
Okay. You have objection to the
Yes,
condonation
Lordship,
of
I
delay?
have two grounds to object.
Okay,
Lordship.
what is that?
Lordship, the title suit was filed on 23/3/2022 by the plaintiff, the respondent here, before the Civil Judge Senior Division Kohima. Thereupon, the applicant have filed IA number 18 of 22 on 23/8/2022 under Order 7 Rule 11 for rejection of the claim, to which the order dated 28/2/2024 was passed. Firstly, my ground is that there is a gross negligence committed by the applicant in filing the instant revision. The applicant is taking the ground that the former counsel has advised them to start searching for necessary documents at a very belated stage, thereby causing delay in filing the present revision petition. This averment is unjustifiable and misleading. The applicant had the opportunity to search, collect, and furnish documents for the past 2 long years. There is no record or evidence to establish that due
Only
diligence.
7, how many days you said?
63.
63 days only,
Lordship.
2 months. 2 months, 3 days,
Lordship.
say 2 months, 2 days. Not 2 years. Only 63 days. And they are department, you are
Yes,
representing
yes,
department.
yes.
Department. Normally it
Lordship.
happens.
My second ground is that the
Okay.
delay may be 63 days. However, it may be it is my submission that the length of the delay is not material and or can be made the decisive factor in determining application of condonation of delay.
Right.
The provision of limitation provides that in order to claim condonation of delay, the sufficient cause should be made
Right.
out and it should be made out and proper reason must be stated thereof seeking the condonation of delay.
That is correct.
Substantial justice must be given primacy over technicalities, and the same does not extend to delay caused by gross negligence or lack of diligence.
Yes.
It is the bounden duty of the litigant to be vigilant about the judicial proceedings pending in the court of law. Thus, the plea raised by the applicant that no legal advice was forthcoming regarding the order dated 28/2/2024, rejecting the application order under Order 7 Rule 11 is unsustainable in law. Lordship, my submission is that the applicants have failed to show any reasonable or sufficient cause for the delay. The law mandates that every single day's delay must be explained. The condonation of the present application will cause irreparable prejudice to the deponent who has been diligently following the legal proceedings ever since the filing of the title suit in the year 2022. On the other hand, the applicants are prolonging the matter purposely, and therefore, if delay is to be granted, then it shall set a bad precedence as containing the deliberate inaction of the applicant would seriously undermine the mandate of the law. The instant application is abuse process of law and therefore is liable to be dismissed. That is my humble submission, Lordship.
What is the matter about actually
Actually,
in the trial court?
this trial court is a title suit filed by the
Title
respondent.
suit is about,
For, yes, for possession as well as declaration of title.
Hmm.
Now, during the pendency of the suit, the petitioner
Hmm.
filed a application for rejection of plea. That application for rejection was dismissed this year.
application for rejection of the
Rejection
plea.
of the plea, which was dismissed and against which.
Your application was dismissed.
Yes, yes, and
Okay.
against this, which order I'm before this court. Against the order rejecting my application for rejection of plea.
Now, what do you want there?
Now, in the main,
Yes.
no, in the
Who
IJ,
files the title suit?
the plea, the
I
respondent,
filed the
yes,
title suit,
Okay.
Lordship.
against the forest department.
Okay, so you file application for
For
rejection of the
plea
plea.
on the ground that there's no cause of action and being barred by
Now,
limitation.
why you want to revive that one then? You want to file another?
Yes, because if your lordship would see the claim of the plaintiff,
Hmm.
it's, she relies on a
With better
document.
contest there,
Yes,
better contest there.
no. As far as the plain is concerned, I'm positive that there's no ground for proceeding with the plain
Yes.
suit.
Then
Now, in
contest.
the IA for limitation,
Hmm.
I have stated at paragraph 4 and 5 and 6,
No,
the
no,
reasons
so
for delay. Now,
by the impugn order, what is the impugn order says?
no, the impugn,
By the impugn order,
yes.
what order was passed?
If your lordship wants to go to the impugn order, then it's at page 13.
1-3,
Yes, page 13,
yes.
dated 8
This
February.
was filed, no, this is filed by state of Nagaland only.
Yes,
Yes, that is why,
No.
who is the plaintiff?
the plaintiff is the private respondent. Now, we file the application, of course. So it's
Okay.
the state of Nagaland versus the plaintiff.
So the IA, you have.
Yes, yes.
IA for
For rejection of the plea.
rejection. What do you want to revive that one?
Now, the claim of the plaintiff, I have to enter into the merits.
Yes.
The claim of the plaintiff is that a declaration was made by his father
Hmm.
in the year 1987.
Hmm.
Now, prior to that, the forest department had purchased the land in the year 1970. Quarters and offices were constructed in our land.
You contest the title. You're contesting otherwise.
Yes, of course, I've also filed my
Ah.
written statement, but I'm saying that insofar as the plaint is concerned,
Ah.
there is no cause of action and the plaint is barred by limitation. Now that those aspects has been miserably construed by the trial court.
So you want to file
And against
revision
which I'm
against
before
that,
this court.
revision
But
against that.
yes, in doing that, there's a delay of 63 days. Now,
Anyway, what we
that-
can do is since you have already filed, so revision, let us try to see decide the revision on merit. Delay is only 63 days, and that is department. Probably he has made out some cases.
at paragraph 4, 5, 6,
Hmm.
yes, the reasons are
Four.
stated. Yes.
What is the,
Initially, how it happened was after the disposal of the application, after the rejection of my application for
searching of all the
Yes.
necessary documents
at
from the
4.1,
department?
4.2, now the advice of the council was also lacking
Hmm.
to proceed further against the order. And against which I have also enclosed all the documents, necessary documents. If your lordship may kindly come to page 21.
Please,
Page 21.
what is 21?
Now here, on this date, the earlier council representing the petitioners failed to
Well,
appear
this
before
is
the court.
before,
Failed to appear before the court. And in view of it, the court had rejected the opportunity or to the defendants in a suit.
earlier,
Yes, somebody was representing.
somebody represented.
And on this date, he failed to appear to counsel.
So this is prior to the
Yes, and
rejection.
yes, and no, after the rejection.
Oh, no, after rejection. So,
But there was no advice from the council to the department to prefer an application against the order dated 8/2/2024. Pursuant to which this order came, 2012 12 June 2024.
Okay, there was no advice from the council. to-
Yes, to prefer
Hmm,
to challenge the order dated 8/2/2024.
means the
Yes,
impugn order.
and- yes, and I've also stated that, and in fact, what the council did was advise the department to search for all the documents, relevant documents, to prepare the written statement.
Okay.
And after that, on 12/6/24, on this date, the council failed to appear, because of which the court said that no further opportunity would be given to the forest department to file a written statement.
Hmm?
Pursu-
No opportunity?
Yes, no opportunity to file a written statement to the forest department.
Okay, that
Yes.
order was also passed.
Yes, and pursuant to which.
So you have challenged which order?
Yes. No, I'm challenging the main order, which is at
Main
page
order.
13, yes. Now pursuant to which,
So where do we find that? Yeah,
at page 13, your lordship.
page, no. Where it says that department is debarred from filing
Oh,
written
yes.
statement,
Paragraph 4, at page 21, paragraph 4,
page,
without giving further opportunity to the defendants in the file. And then after that, the council withdrew from the case, for which I've also annexed the application.
On 12/6/2024,
yes.
defendant did not appear.
Yes,
Counsel.
the council did not appear, unfortunately, yes.
Okay, so that can be because of the ill advice of the council, it appears.
Lordship, my grounds for rejection are at paragraph
Or-
4 and 5 of my written objection,
Hmm,
if your lordship would refer.
okay, anyway, so.
There we
it's
can
the
enter into the
department
next
want
ritual.
opportunity can be given. Okay, heard, Mr. Ilalo, Land Council for the applicant. I've also heard Miss
Roviman.
Land Council appearing on behalf of the opposite party. Opposite, how many? Only one.
Sole private respondent.
Okay, start. Start. This is an application under section 5 of the Limitation Act 1963. Praying for condonation of delay of 63 days in filing the connected civil revision petition against impugn order dated 28/2/2024, passed by the Learned Civil Judge Senior Division, Kohima, in IA within bracket civil bracket close number 18/2028/22, arising out of title suit number 01/2022, whereby the applicant's application under order 7 rule 11 CPC was dismissed. Start. Start. The ground for delay in preferring the connected appeal has been stated in para 4.
Yes, 4.1, 4.2.
4.1.
Yes, 4.1 to 4.9.
4.2, 4.3, 3
4.9.
to 9.
Yes, 4.9.
Okay,
And
4.
paragraph 5 and 6 as well.
4 to 4.9
4.9 and 5 and 6 as well.
and
Paragraph 5, 6.
and in paragraph 5 and 6 of the application. Start. The ground stated, among other, is that the earlier advocate who represented the appellant department after passing of the impugn order dated, what is the order?
28
to 2024. Did not advise the did not properly advise the department to prefer appeal, sorry, revision
Yes.
against the impugned order. And the said council also did not appear before the court on 12/6/2024. There is after filing this or?
Yes, so the limitation was after 60 days started.
Okay.
Yes.
Due to which the suit was decided to proceed further without giving further opportunity to the defendant stroke applicant hearing. Thereafter, the department has engaged the present counsel and who instructed the department to collect all the necessary documents pertaining to the suit to prepare a, no, pertaining to the suit. No, this is regarding written statement only. And in the process, there has been a delay of about 63 days in preferring the present revision petition, connected revision petition stuff. The Honorable Counsel for the applicant submits that the delay was not deliberate. Where have you stated that it was? not-
Paragraph 5.
Hmm?
5. Page 8.
Delay was not intentional or deliberate. And the delay cause was beyond the control of the applicant. Hence, pray for condemnation of the delay in filing, preferring the connected appeal. Miss, no, sorry, the Honorable Counsel for the opposite party now, on the other hand, the Honorable Counsel for the opposite party oppose condoning the delay of 63 days on a ground that with one or the other reason, other ground, the applicant is adopting a delay technique. And then, so no, so just. And by doing so, the applicant is abusing the process of law. Stop. Hence the delay may not be condoned. And prays for dismissal of the application. Not stop. Upon having heard the parties, I'm of the view that I'm of the opinion that the department, the applicant department has shown sufficient cause for not preferring the connected revision petition within a stipulated period of time. Accordingly, a chance can be given to the petition, the applicant department. So in view of the above, the delay of 63 days in preferring the connected revision petition is hereby condoned. This application with the above this application stands allowed and disposed of. It has been registered, not yet.
It has been registered.
Registered.
It has been, yes.
Okay.
Revision petition
The-
number 14.
Okay.
If the LCRs may be pulled.
The registry may list the revision petition. Register may already registered.
Yes, it has been.
Register and list place the revision petition on the date to be fixed by the registry. Well,
Lordship, can we call for the LCR?
register, okay, just a minute. This is revision petition.
Yes.
Okay, then, okay, in the main, huh? Mr. Iralo, Land Council for the petitioner. I've also heard Land Council for the petitioner, huh? Petitioner. Call for. Just a minute, huh? The revision petition is admitted. Call for the scanned copy of the trial court record. Issue notice, returnable by 4 weeks. Since Miss Harnan has already appeared and accepted notice on behalf of the sole respondent, no formal notice need be issued. Stop. List is matter after 4 weeks.
Be obliged.
For all others, item number 18.
May I please,
Yes.
Your Lordship? Notice upon all the respondents are still awaited.
Still awaited.
Yes, Lordship. And Lordship, as per the last court order, we have already filed our amended cost title.
You have amended.
Yes, Lordship.
Where it says that you have to amend the post title.
Oh, Lordship, we have filed in IA,
IA
yeah, for impleadment.
for impleadment.
Yes, Lordship.
Any order passed in the IA? No.
Yes.
Where is IA? Okay. Miss Im Chen, huh? Ayala Im Chen, learned counsel for the petition. Who submits that? She has already, she has filed. The she has already corrected. It's a correction only.
Yes, Lordship.
Okay, she has already filed amended post title, huh? And you have taken steps upon the respondent.
Yes.
Okay, and taking steps upon the respondent. The newly impleaded respondent.
Yes, Lordship.
Okay. However, the notice upon the newly impleaded respondent is still awaited. In view of the above, list is met after 2 weeks. 2 weeks. Is this the last? Okay. You serve the new, this amended one
Yes.
to the newly impleaded
Yes,
respondent.
No. You have to mention.